Good day everyone. Are you an alternative dispute resolution practitioner conducting mediation, arbitration, or any other form of ADR mechanism? Do you have what it takes to be OADR accredited and offer services to government agencies and have partnership with them thereafter? Let's get to know the fundamentals and requirements for the OADR accreditation, and you can be one of us. Now, it's time for us to dive in and get to know the OADR accreditation. Here is a summary of the 6 key points that we have to keep in mind. First, the OADR accreditation is mandatory only for ADR providers offering ADR services to the government or have partnership with said agencies. Government agencies shall only partner with, or engage the services of OADR accredited ADR practitioners. Once accredited, they may provide ADR services to government agencies, such as, but not limited to serving as an ADR practitioner, providing ADR training, conducting program and system design, and managing, overseeing or administering ADR programs. Second, the OADR confers accreditation to individual ADR practitioners, private APOs, and public ADR program who have successfully complied with the requirements under DOJ Department Circular 49, Series of 2012. Third, an OADR certificate of accreditation is valid for a period of 2 years from the date of issuance or unless sooner revoked. It is renewable and shall only cover the field of practice, or the ADR mechanism indicated therein. Fourth, any certification or accreditation granted to an individual ADR practitioner by an OADR accredited private or public APO with an ADR program shall be recognized by the OADR for the period within which said APO remains accredited. Fifth, accredited APOs that intend to offer ADR trainings to government agencies are required to obtain approval from the OADR at least 1 month prior to the intended training date. And lastly, the updated official roster of accredited neutrals and APOs are posted online via the official OADR Facebook page, and the OADR webpage and the DOJ website. At this juncture, we are proud to present to you the updated roster of accredited practitioners per category. For the first category, we have the private ADR provider organizations or the APOs. Presenting, the Conflict Resolution Group Foundation Incorporated, the National Center for Mediation, the Philippine International Center for Conflict Resolution, Philippine Dispute Resolution Center Incorporated, the Philippine Institute of Arbitrators Incorporated,
the Mediators Network for Sustainable Peace, Incorporated,
the Philippine Arbitration Center in the Visayas, and the Calao, Prasad and Hofeleñalo.
For the second category, we have the ADR practitioners and neutrals. Presenting, the OADR accredited individual ADR practitioners and neutrals. For the third and last category, we have the Public ADR Program. Presenting the Intellectual Property Office of the Philippines. In summary, here are the figures on OADR accreditation as of this date. Any interested applicant may submit the following requirements for OADR accreditation. For ADR provider organization, for individual ADR practitioner or ADR neutral. And for public ADR program. For any questions and concerns, you may visit the OADR Facebook page or email us at acd.oadr.doj@gmail.com. Thank you.
Good morning. Before we formally start the program, please take note of the following important reminders. Foremost, please be informed that this convention is recorded. By joining, you are giving consent to the Office for Alternative Dispute Resolution or the OADR to record and maintain a copy of these proceedings and any information that will be exchanged throughout this event. Please observe proper decorum. Refrain from using offensive language and keep your comments relevant to the discussions in the event. Meanwhile, the post-event survey shall be posted on the OADR Facebook page following the third day of the convention. Please note that only those who registered, attended, and accomplished the post-event survey will receive an e-certificate. Should you have any reservation or related concern, kindly contact the NADRC Secretariat at nationaladrconvention@gmail.com. Please stand by. The program will begin shortly. With that, we now commence the program with an invocation to be followed by the singing of the Philippine National Anthem.
Lead me, Lord, lead me by the hand and help me face the rising sun. Comfort me through all the pain that life may bring. There's no other hope that I can lean upon. Lead me, Lord, lead me all my life. Walk by me across the lonely roads that I may face. Take my arms and let your hand show me the way. Show the way to live inside your heart all my days, all my life. You are my light, you're the lamp upon my feet. All the time, my Lord, I need you there. You are my light, I cannot live alone. Let me stay by your guiding love all through my life. Lead me, Lord, lead me, Lord. Even though at times I'd rather go along my way, help me take the right direction, take your road. Lead me, Lord, and never leave my side all my days, all my life. You are my light, you're the lamp upon my feet. All the time, my Lord, I need you there. You are my
di ba'y buhay. Upang ibigang tuyang ka ng makinig sa matulungin, di ka masisi sa darating pagsisiyod at sa langit magkakauloy ng haptulan at awit sa paglayang minamahal. Sa bawat kita may nanatinig, mabituin at araw niya kailan pa may nagbibigay.
Once again, a pleasant morning to our distinguished guests, dear participants, ladies and gentlemen. Welcome to the second National Alternative Dispute Resolution Convention, or the NADRC 2021, Day 3, organized by the Office for Alternative Dispute Resolution, or OADR, an attached agency of the Philippine Department of Justice. At this point, allow us to thank all of you for joining us and supporting this event. We very much appreciate your overwhelming presence online through our Facebook and YouTube live stream. By looking forward to better days ahead, we are hopeful to have you all with us in our future undertakings in our advocacy towards the institutionalization of ADR in the flagship. Previously on this convention, we learned about how the ADR has transformed in the digital world as well as the online dispute resolution mechanisms through our esteemed resource speakers from here and abroad. This morning, the convention's finale shall focus on regulating the online dispute resolution, or ODR, with discussions on the leading technology solutions for digitalizing ADR and the integration of the ODR into the legal system. Informative and enlightening as it is, we still have a lot in store for you in this finale of the NADRC 2021. Stay tuned to our official online channels, the Office for Alternative Dispute Resolution on Facebook and YouTube, as we provide you with timely information, updates, and discussions on alternative dispute resolution in the digital era towards enabling a more efficient, accessible, and effective administration of justice in the Philippines. And now, we open the program with a keynote message from our distinguished guest. Ladies and gentlemen, let me introduce the Principal Counsel and Team Leader of the Law and Policy Reform Program of the Asian Development Bank, Ms. Christina Pak. Ms. Christina Pak specializes in international development finance, law, and policy reform. She is currently a Principal Counsel of the Asian Development Bank, or ADB, and is responsible for managing the Office of General Counsel's Law and Policy Reform Program, which designs, processes, and implements technical assistance projects directly to developing member countries relating to legal and judicial reforms. Christina specializes in dispute resolution and leads ADB's international arbitration reform initiatives. Christina also serves as ADB's Accountability Mechanism Policy Counsel and the Office of the General Counsel's Technical Assistance, Partnerships, and Knowledge Focal Point, and is a steering committee member of ADB's Gender Equality and Environment thematic groups. Prior to joining ADB, Christina was a legal counsel and vice president for markets and international banking at a major UK bank in Singapore and a finance associate at a large law firm in New York City. Christina is also a steering committee member of the IUCN World Commission on Environmental Law and a member of the Chartered Institute of Arbitrators. She is a U.S. qualified lawyer admitted in the states of New York and New Jersey. Ladies and gentlemen, let us all welcome Ms. Christina Pak.
Introduction. A very good morning to everyone, to Undersecretary John Paulo Salbahan, distinguished speakers and colleagues. It's a privilege to be part of this important conference. And it's wonderful to be joining from the Philippines, where ADB's headquarters is located. Of course, Philippines has been ADB's key development partner since our establishment in 1966. I extend my special gratitude to the Office for Alternative Dispute Resolution of the Department of Justice for inviting me to deliver remarks at this important and timely conference, given the evolving landscape of dispute resolution in all realms. So today's the third day of the second National Alternative Dispute Resolution Convention, and a lot of rich discussions have taken place so far. So I'd like to focus my talk on why effective dispute resolution is so important to the Asia and the Pacific region, and walk you through some of the dispute resolution developments in the region and offer some observations. So why is effective dispute resolution so important? From ADB's perspective, effective dispute resolution is critical in supporting many key areas of development, such as fostering FDI and cross-border trade, supporting private sector and PPP development. It also facilitates environmental protection and contributes to climate change and promotes gender equality, and it helps expand the digital economy. And ultimately, it helps to achieve the Sustainable Development Goals. For over a decade, ADB has been supporting various dispute resolution initiatives in our region. For example, under our Judicial Capacity Building Program, we have been working with judiciaries in the effective and efficient adjudication of commercial disputes, environment and climate change disputes, and more recently, gender-based violence cases. And during the last 5 years, ADB has been supporting international commercial arbitration reform in our developing member countries. In fact, international arbitration as a way to resolve commercial disputes is very much embraced in the Asia-Pacific region and has proven to be fundamental in attracting FDI and trade with countries in other parts of the world. And it's becoming more relevant in other areas, such as attracting international climate finance and resolving climate change-related disputes. International arbitration is preferred over litigation in the national courts because it provides parties with key advantages, such as flexibility and ability to choose a neutral forum, impartial arbitrators with subject matter expertise, flexibility of procedures, and choice of governing law, as well as other benefits such as confidentiality and privacy, and oftentimes cost effectiveness. And most importantly, ability to enforce a foreign arbitral award in 169 countries under the New York Convention. There is already a well-established legal infrastructure in place for international arbitration, namely the New York Convention and the UNCITRAL Model Law on International Commercial Arbitration. Both of these instruments are relatively easy to adopt and have potentially outsized benefits. By adopting these two instruments, states can quickly establish a framework for resolving international commercial arbitration and reap the corresponding benefits. So initially, ADB focused on the South Pacific region as it was one of the last places in the world without a legal framework for international arbitration, which stifles their economic potential. Also, it is important that these smaller economies have equal access to international arbitration, given that FDI plays a greater role in their economic development. So in 2016, ADB approved a technical assistance project to support the South Pacific countries and Timor-Leste to accede to the New York Convention and put in place the implementing arbitration law, as well as provide capacity building to judges, lawyers, and the private sector. When we started out our work in 2016, only 3 out of 14 South Pacific countries were signatories to the New York Convention, and most did not have the implementing arbitration laws in place. It was a similar case for Timor-Leste, which was trying to diversify its economy with ambitions to join the WTO and ASEAN. Fiji was one of the early movers in enacting international arbitration reform. It had signed on to the New York Convention in 2010, but needed to enact the implementing law. So ADB in conjunction with UNCITRAL, assisted the Fijian government enact what we believe is a state-of-the-art International Arbitration Act based on the UNCITRAL model law with best practices adopted from leading seats such as Singapore. We also assisted Papua New Guinea accede to the New York Convention in 2019, as well as Palau and Tonga in 2010. And earlier this year, Palau and Tonga enacted the implementing international arbitration laws, also based on the UNCITRAL model law and international best practices. In fact, this reform was part of their COVID recovery efforts. Also, ADB is assisting the government of Uzbekistan with international arbitration reform and helped with the enactment with the new law on international commercial arbitration in February this year. And currently, we are assisting with drafting of the ancillary law to set out the procedures. And we are also working with the economic court judges in capacity building. We are also working with judiciaries across the region on international arbitration capacity building, as the judiciary has a supervisory role in international arbitration proceedings. And this is very much welcomed by the governments because it is part of their efforts to improve the investment climate. Additionally, ADB is also going to start supporting international trade and investment agreements, including capacity building on dispute resolutions mechanisms thereunder. It's important for government lawyers and others in charge of managing and handling disputes to understand the complex dispute resolution mechanism, especially in the context of changing landscape with the ongoing reform efforts in investor-state dispute resolution and trade disputes, as well as understand the sustainable development implications under the new and the old generation of treaties. Now, moving on to mediation, there is a growing and unique value of mediation in the commercial sphere. And with the entry into force of the Singapore Convention, our toolkit of dispute resolution options has gotten bigger. Should the parties choose mediation as an option, depending on the subject matter and relationship between the parties, there will be confidence that international commercial mediation settlement agreements will be enforced globally. Also, mediation is now an integral part of arbitration. For example, SIAC's ARB and NADRC protocol and the use of multi-tiered or hybrid clauses. The uptake of Singapore Convention has been good, with ADB's developing member countries, including the Philippines. But once countries sign on to the Singapore Convention, they will need to put in place the implementing law. Furthermore, judges will play a new role and will need capacity building. So this is an area that ADB will add to our judicial capacity building program. But ultimately, uptake of mediation will depend on international business. It will depend on the international business community and effective implementation of the Singapore Convention. Also, there is ongoing initiatives to provide for mediation for investment disputes. For example, ICSID has developed a set of mediation rules, especially tailored for investment disputes. Again, as to when mediation is a suitable option for investment disputes, depends on the parties, their relationship, their goals, and how much control the parties wish to retain over their dispute settlement and outcomes. There is also call to increase uptake of mediation in state-to-state disputes for smaller disputes that may cause friction between the states. And as I mentioned before, arbitration and mediations can also play a role in resolving climate change related disputes. Climate change disputes are vast, they're increasing and quite complex and technical, where legal issues are multidisciplinary, involving many areas of the law. And it involves wide range of claimants and defendants from multiple sectors. Although most of the climate change disputes have been brought before the national courts, there is a role for international arbitration and ADR in the resolution of these climate change related disputes. For example, again, it can offer advantages such as expertise and efficiency. Recently, major arbitral institutions have turned their focus on how best to facilitate the efficient and effective adjudication of climate change related disputes. For example, the ICC's Task Force on Arbitration of Climate Change related disputes, they published a detailed report looking at what features could be required and to effectively resolve climate change related disputes. But one big issue is the tension between confidentiality and transparency in these types of climate change related arbitrations. Of course, the disruptions caused by the COVID pandemic has brought new challenges and opportunities. It has provided ADR professionals with the chance to embrace digital means to conduct their arbitration hearings and mediations. This has resulted in efficiencies, less carbon footprint, and innovations in ADR, such as new procedures to provide for virtual hearings and safeguards to protect due process confidentiality and security. Finally, technology has added another option to our dispute resolution toolkit with the development of online dispute resolution, which is particularly suitable to the growing number of disputes resulting from e-commerce transactions. So these are high volume, low value disputes, which need faster dispute resolution, inappropriate for the longer process in national courts, and even unsuitable for regular arbitration, which handle larger and more complex claims. So according to a study by the APEC Business Advisory Council, dispute resolution is one of the greatest challenges faced by MSMEs when trading across borders, with 94% of them reporting that it is a problem. Another study reported that as many as 35% of cross-border disputes involving MSMEs remain unresolved, with average value of disputes being around US dollars 50,000. So ODR can serve as accessible, expedient, and inexpensive settlement mechanism that can facilitate more cross-border trade and increase participation by the MSMEs in international commerce. And regional bodies such as APEC and ASEAN have been promoting ODR. They have developed ODR frameworks to help with regional harmonization, which is a very welcome initiative. For example, APEC adopted the ODR collaboration framework and the model procedures rules, which together help MSMEs settle cross-border e-commerce disputes. And ASEAN is planning to develop the ODR guidelines and mechanisms for cross-border complaints and investigation. However, ODR is still at early stages of development and needs the support of governments and uptake by businesses. One key challenge, again, is harmonization of the platforms and rules, and again, initiatives such as initiatives by the regional bodies are much needed. There are other issues such as due process and procedural fairness concerns and enforcement of ODR outcomes. And there is the question about current legal and regulatory frameworks, whether they are sufficient to address the emerging technologies and how the new rules can be tailored for these emerging technologies. However, over time and with collective efforts, I am confident that these challenges will be addressed. In conclusion, ADR has proven to be agile and able to evolve with the changing development landscape and can be tailored for different types of disputes and for different contexts. Also, ADR has benefited from the technological advancements. ADR in many different forms should be further developed and supported in the Asia-Pacific region, given its significant positive development impact. I will end here, and once again, a big thank you to the organizers and all of you for tuning in. Maraming salamat.
Thank you very much, Ms. Christina Beck, for your message and for gracing this convention. Let us now get started with the program session on leading technology solutions for online dispute resolution. This is where we get to know the top technology solutions for digitalizing ADR. For this, we introduce our first speaker featuring blockchain based document processing. We have Mr. Ernie Teo. Dr. Ernie Teo is the CTO and co-founder of Dedoco, a digital signing and document solution with enhanced privacy and security for sharing and signing of transactions. The blockchain application in this solution also allows the tamper-proofing of documents and an audit trail for authentication and validation. Ernie has over a decade's experience in economics and technology research. Prior to Dedico, he was a research scientist at the IBM Center for Blockchain Innovation and was involved in blockchain projects covering provenance, finance, transport, and logistics. Ernie is active in the blockchain community in Singapore, giving talks and seminars both in industry and at universities. He is the chairman of the Blockchain Association Singapore. Pioneer of blockchain education in Singapore, he conceptualized and taught the first blockchain course as part of a degree program at the National University of Singapore. Ladies and gentlemen, let us all welcome Mr. Ernie Teo.
Hello there. Hi, everyone. Thanks for having me at this conference. So today I'm going to actually talk about my company's product, which is Didoco, which is a document process management system based on blockchain. I'd like to demonstrate today the use of blockchain and its use for performing due diligence and making due diligence processes easier to check and easier to be verified. Right, so this is our platform. I hope everyone can see my screen. And our aim is to provide you with a better way to get your documents signed and verified and to digitize your paper processes. So Didoco is a first of its kind digital document and signing solution, and we seek to transform the way enterprises manage digital workflows while issuing trusted, verifiable documents and credentials. And our solution is built with the aim of improving efficiency and compliance while ensuring document security and privacy. So we help enterprises digitize their transactions with an easy to use software as a service that can be adopted across all industries. So what are the problems that we are trying to solve? Number one, the logistical nightmare, right? Many industries still rely on a lot of paper and cumbersome document processing flows. Physical documents and signatures are very expensive, time-consuming, and an administrative pain, right? So you have to do a lot of verifications and checks. There's a lot of time and cost spent on querying documents from one place to another just to get it signed. You incur a lot of filing and storage costs. A lot of times, different companies along the ecosystem will have to do manual data entry when they receive a paper document, although it was printed out as a digital, from a digital system, right? Of course, you have to pay money for printing and faxing and tracking and delays. So there is a lot of this kind of administrative problems, especially when it comes to dispute resolution later on, right? So after you have signed certain agreements or contracts and the disputes arises, then there is a lot of administrative work as well in pulling out the relevant evidences that is required to prove that you are right? And for both parties, right? So this is all a very big problem, and a lot of time this evidence get lost. Right? For example, some of the evidence may lie within an email of a colleague that has left the company, right? Then these become even more problematic. Right, the other problem that we are trying to solve with the platform is data privacy and security, right? A lot of cloud solutions that offer e-signing are centralized solutions, and they store their documents within their cloud network, typically without expiration. and therefore they are highly susceptible targets to sophisticated cyber attacks. So, and your classified company data potentially can be accessible by third parties. So by using cloud-based digital signing solutions, you're entrusting the providers to keep your documents confidential. So in 2019, a team of academics in Germany managed to break the digital signing system and create fixed signatures on 21 of 22 desktop PDF viewer apps and 5 out of 7 online PDF digital signing services, including Adobe Acrobat Reader and DocuSign, just to name a few. Right, so there are all sorts of attacks that can happen on PDF files. So our approach is to actually go decentralized, and we use blockchain as a mechanism to store evidence of the documents as when they are being signed and after they have been completed signing. And this evidence becomes tamper-proof on the blockchain. So if someone does tamper with your PDF files after the signing process is completed, then it will not match our evidence on the blockchain, and therefore we'll be able to identify that some tampering has been done. So why use Didoko? Right, our vision is to be the enabler of trusted, verifiable, and connected digital documents. With Didoko, a document can remain digital in its life cycle, connected from system to system, with an issuance and chain of custody being digitally verifiable and trusted. So no data is stored with Didoko. So no digital documents are stored with Didoko. It ensures the document privacy and data privacy. So how do we achieve that? So what we do is when you prepare a document to be signed, we take a digital thumbprint of the document and store that on our blockchain, but not the actual document. So when it comes to document processes and signing, the most sensitive part is actually the document itself, right? Because these are contracts, these are agreements. They may contain sensitive information about the parties, including your contract amounts and things like that, right? So we don't store the actual document. We only store a digital thumbprint of it. And when the signers sign, they retrieve these files directly from the preparers' databases. And that allows them to be able to sign the document. It allows us to capture the evidence, but at the same time, our platform itself don't store the digital document permanently. Tamper-proofing. So by using our blockchain technology, we are able to ensure tamper-proofing of these documents while they are going through the process and after they have gone through the process. Right, it allows the document to be verifiable throughout its life cycle because one can verify whether any change has been made to the document after any part of the process. We also make our system very modular. We provide different API services that allow for simple deployment for integrations and non-intrusive to your current platforms and systems. So we allow you to integrate your applications to us where you can trigger signing processes, and therefore you'll be able to easily plug in rather than have to use our the web platform directly. We're also multi-cloud. We enable different types of deployment. We have done hybrid deployments or on-premise deployments with enterprises as well. So these are the 4 key features of our platform. We allow digital signing or electronic signing. So there are options to doodle, type, or upload. We capture e-signatures, but we also capture digital signatures. For example, in Singapore, we have a digital signing service that is provided by the government, and we integrate with this digital signing service, which allow a trusted signature to be appended onto the PDF document. We have a verifying service, a verifying feature where you can verify if your documents are tamper-proof, you can verify its audit trail, and you can do real-time verification of the documents. We have a form feature where you can generate forms and templates where someone can easily fill up the forms and sign the forms and send them to your organization. And we allow capturing of the completed form data. We also have some workflow management features on our platform. We don't store the documents on our servers. We have inter and intra document processes. and workflow and risk management. Here, let me show you an example of a certificate that is created out of our document signing process. So, I don't really have a lot of time to show you an actual demo. So let me walk you through the process a little bit. So in our document signing process, we have two types of roles, right? We have a preparer. A preparer is someone who uploads this document and assigns different functions to the recipients. Right, there are different kind of recipients that after they receive this invitation will act on this invitation. So this is an example of a employment agreement that is completed and has been signed. Now let's imagine this process where internally within the company, in order to issue an employment agreement, we need a director's approval. Right. However, we don't need the signatures to physically appear on the document. Right, so our platform allows you to both do a visible signature on the document as well as an invisible approval. Right, so if we look at the evidence here on the right, we see that we have the director's approval, and we capture the evidence and the audit trail of this, that the director has indeed approved this employment agreement. And we see that the hiring manager has signed on the document at a particular time, and the employee himself, Sam Lee, has also signed on the agreement at a particular time. Now, all these processes are document-centric. So what I mean by that is, with the signed employment agreement, you can verify it directly on our Didoko platform, and you will be able to retrieve this document. So imagine, a few years down the road where there's dispute over this employment agreement, or there's an auditor who wants to check what happened, whether this document was performed, the signing was performed properly, whether the due diligence has been done. You can simply just take the signed PDF document and query it on our platform, and you can retrieve these evidences here that I'm showing here on the screen. And therefore, you don't have to go into email, go and find the email from a few years ago just to show that the director has approved. And you don't have to find pieces of evidence from different systems. So that's the idea behind our platform. So who do we serve? We work a lot with banking and finance customers. Many of our customers here based in Singapore are from the finance industry, legal firms, property firms, and professional services firms such as CorpSec services also utilize our platform. We also work with government services here, where we allow government forms to be signed using the National Digital Identity. Right, so that's the quick overview of our platform. Right, if you're interested to find out more about our system and application, do feel free to contact us at hello@didoko.com. I'm sure the organizers will be able to provide you with more information about our company as well, if you're interested to find out more. All right, so that brings me to the end of the presentation. Thanks very much.
Much, Mr. Ernie Teo. For our next speaker, we introduce to you the Flamingo AI Chief Information Officer, Mr. Darren McVeen. Mr. Darren McVeen is an experienced software, media, and gaming executive, having managed and founded numerous businesses, including blockchain software development, artificial intelligence, gaming, and secure real-time messaging companies. As the CIO of Flamingo AI, Darren is responsible for all technology, business, and product development decisions. Flamingo AI is an Australian software as a service business specialized in artificial intelligence, collaboration, and customer experience. Ladies and gentlemen, let us all welcome Mr. Darren McVeen.
Hi, ladies and gentlemen, and distinguished guests. Thank you very much for the opportunity to speak today. I'm the Chief Information Officer for Flamingo AI. Flamingo AI is an artificial intelligence company that has been listed on the Australian Stock Exchange for around 7 years. We have invested around $20 million US, building a number of applications which are used in the banking, finance, SME, and now government sectors. Our artificial intelligence platform is, it takes a number of forms, but it basically is a web-based platform that provides an organization or a government department or a bank to enable its staff to securely log into a private dashboard or web-based system that they can then access information about their organization with assistance from artificial intelligence. So with artificial intelligence, you have narrow artificial intelligence, or you have general artificial intelligence. Narrow artificial intelligence is very, very specific artificial intelligence for a certain application. So that could be for stock markets or price discovery, and it's where an algorithm is designed for just one very narrow application. General artificial intelligence is where the algorithm is able to take unstructured data. So think of things like Google or Siri, and now the artificial intelligence is able to take data that has not been structured or prepared, and the artificial intelligence is able to identify it, to learn from it, and present that to employees or who needs access to it in a useful manner. And so a lot of our customers are global banks, insurance companies, and some governments, and their employees will log on to the system, and they can basically just ask any question. And the platform connects to over 400 data sources. So it is able to connect via a middleware API transport to 400 different applications. So that could be emails, instant messaging, accounting systems, data retrieval, could be Confluence, could be Jira, could be social media, anything that is either a closed data silo or a database, or a application that provides an API connection. So now what happens is Flamingo AI will connect to all of these different applications using these APIs, and it will return the correct answer 80% of the time on the first instance. So for example, if this is the first time that I have accessed the system and I've asked it a question about who is responsible for opening this account, who closed this account, who wrote this document, I could ask it any question in natural language. 80% of the time, instantly, it will return the correct answer. Then what happens if it is not certain? It has 3 states. It has certain, and that's where it knows that that is the answer. It knows that Darren altered this document or Darren worked on this project. If it is not certain, then it is either confused or confounded. And both of those 2 other states is where the artificial intelligence algorithm actually seeks to be advised via the employees within the organization. So it may not have the exact answer, but it is pretty certain that it knows within the organization who may have had dealings with this. And it will generate an email, send that to them, could send a text message, or there's a web-based login. And that employee in the organization who is notified may be, they receive an email that says, "Hi, Mary, we believe that you may be able to help in this situation. Here is a question that has been asked. This is what we believe. Are you able to advise?" And if that employee is able to, then they will answer it. It will then go through a validation process, and that will then be returned as the correct answer the next time somebody goes to answer that. If they are not able to answer it, then they are going through a bunch of questions and answers to help identify somebody else in the organization who could identify that. What we are finding is that with some of our global banking customers and insurance companies, that they are able to, as I mentioned, return the correct answer 80% of the time in the first instance. And then through the assistance, it increases significantly, where in most instances, it is a potential cost reduction of 33% through speeding up access to the correct information or eliminating errors. Where our company is going, Flamingo has built a collection of products which we have global patents for, which are used by banks and insurance companies. But we're now starting to bundle this into proprietary applications that assist in very, very specific niches, like dispute resolution. And we are actively looking for groups that are looking to pilot artificial intelligence capabilities, perhaps bundled with, as the previous presenter discussed, there's tremendous applications within blockchain. And we are very much interested in any organization within the Philippines that is looking at how artificial intelligence can assist in dispute resolution. And we would love to work together to build a proprietary system that may benefit the Philippines or other markets. Our contact details are Flamingo AI, and we thank you very much for the opportunity to present today, and look forward to hopefully speaking with you soon. Thank you.
Thank you very much, Mr. Darren McVean. Focusing on business process management, we have our next speaker, Ms. Arshia Notion, the Global Director of Channel Sales, Kissflow Incorporated. Ladies and gentlemen, let us all welcome Ms. Arshia Notion.
Yeah. Hello, everyone. Good morning. So I would like to, present about Kissflow. So Kissflow has been in the automation, that is the workflow automation space for more than a decade, and we believe in the power of simple. So Kissflow is keep it simple and stupid workflow automation, and we have customers across 160 countries, 10,000 customers, and more than 1 million users. Right? These are some of the brands that use Kissflow at a department level and an org level. So we also cater to banks, insurance companies, governments. So anything that you need in to automate for workflow automation, it's available in Kissflow, right? So this is what people say about Kissflow. Why G2 CrowdGrid is because these are verified reviews from real users of the product. So verified users of the product have rated Kissflow as a market leader in the digital process automation space, right? So we beat even Pega, K2, Bizagi, and Salesforce. So now, yeah. So how does Kissflow help in online dispute resolution, right? So how do we help you automate online dispute resolution? So there are three things to arbitration and dispute resolution. First is incident management, and then it is investigative, and then service request, right? So all these three can be done using Kissflow because we have everything. So we have the process module, which can help you automate workflow. So the approval chain and process can be handled. And then we also have an mobile app. So your agents can, upload a picture, or from the spot, they can, raise the cases using the mobile app. And then we have investigative, which can be managed using the case module. So there are like service requests that you can raise, and it can be assigned to the different departments, and they can handle the workflow, right? So which can be regulatory queries, compliance and fraud audit requests, governance. So all this can be handled. And then we have the regular service requests, which is loans, claims, customer service, project change requests. So anything that you need for online dispute resolution is available with Kissflow. So these are the different modules that you will be able to find. Process module is for setting up workflows. Case is for, it's a ticketing module. The project is to manage projects that you want to, handle, and also integrate process, case, and project within the platform. So integration within the platform and externally is also available. You can also collaborate with, so you can create a community of, so a citizen community, and then you can have a collaborative environment on the platform. So good analytics is also available, right? So let's get into in detail about how we help. So collaborate, we have, unlimited channel, poll, surveys, announcements, moderate, and so you can maintain a very good citizen community portal using Kissflow. So it looks similar to Facebook. So you can make announcements about any new, policies that you have, and to ensure, all of them are updated. So it goes as a post in the feed, and also it goes as a email to all the community members. And then you also have a chat module in case your citizens need regular chat based support. It is inbuilt in the product. Coordinate, yeah, like I said earlier, we have the case management, where you can create, track, and manage case, both internal and external. So this is how a case board will look like. So you can have a list of cards in the not started stage, and then you can have some in the planning, execute, and then complete, right? So this is how you can manage your projects. And then issue tracking, which is like the tickets, you can have multiple status, and this is also available as a board view, right? Coming to control now, how do we enable workflows? So be it like how Didoco showed that they have a document automation process. Here, everything can be automated. It can be document, it can be any process that you want to automate. So there is sophisticated access control. There are proper SLAs and deadlines that you can define, and you have dynamic workflow routing, which is like you can have rule based routing as well as based on. So if you have like 5 agents to handle the workflows or the processes or tasks, you can do it in like round robin or least loaded method. So advanced assignment methods available. This is how a process dashboard looks like. So you can also track the progress. You can also see the transition uh, as to how long did it take to complete this particular task, right? Coming to integrations, why integrations is a key is because we know there will be legacy systems in your existing environment which needs to be integrated. So we integrated using APIs, REST APIs. But in case if there are too many legacy systems and it needs a enterprise service bus, we do that as well. So this is a simple screenshot from the product of how integration looks like. It's very easy to configure. And coming to analytics, we have various reports, pivot charts, process metrics. We have 12 chart options. So all this is made visible in Keyflow. So this is like an aging metric chart that we are showing you. So you can track how many are more than 180 days which are pending and with whom it is pending, and which are pending in the 7 to 20 days, 2 days range, and how many tasks are pending with deactivated. So some agents leave your organization or leave your setup. You can also reassign these tasks to active users in the organization. So what is the ROI that you get from automation? First is you save time. So you can process 12 times as many requests per hour according to a study by iPayables. You save money. Each paper request costs anywhere between $12 to $30 to process. So you can save per paper request, you can save around $12 to $30. Better visibility. So you get visibility of everything. You get approved documents, tickets, workflows. So anything that you need visibility about, it's available. High efficiency. So your agents need not track on email, phone. So they get a a unified system where they can track all the dispute cases in one place. So I also would like to introduce ICO today, who is our local partner in Philippines. So we have local support available for you. You can connect with Jeremil at md@ico.today to know more about Keyflow. Yeah, that's it. Yeah, thank you.
Thank you very much, Ms. Arshia Notion. That leads us to our next topic, the integration of online dispute resolution into the legal system. For our first speaker on this segment, we have Ms. Teresa Rodriguez de las Heras Baliel, arbitration judge at the Court of Arbitration of Madrid, Spain. Ms. Teresa Rodriguez de las Heras Baliel is a professor of commercial law at University Carlos III of Madrid, Spain. She is an arbitrator at the Madrid Court of Arbitration and the Spanish Court of Arbitration and a number of the Spanish Advertising Standards Tribunal, the European Commission Expert Group on Liability and Technologies Formation, the Expert Group to the EU Observatory on Online Platform Economy, and a delegate for Spain before the UNCITRAL Working Group 6 on Security Interests. She has held fellowships at the European Central Bank Legal Research Program 2018, with a project on fintech regulation, the Transatlantic Technology Law Forum, Stanford Law School, and was a Marie Curie Fellow at the Center of European Law and Politics, University of Bremen. In addition, she has held visiting professorships in a number of universities and research centers such as Columbia Law School, University of Washington, University of Tokyo, and University College of London. Her research and publications mainly focus on digital law, secure transactions, and finance law, digital economy, and international trade. Ladies and gentlemen, let us all welcome Ms. Teresa Rodriguez de las Heras Valyel.
Good morning from the city of Rome. Thank you very much for this invitation. I would like to thank the Office for the Alternative Dispute Resolution of the Department of Justice for this kind invitation. I am very pleased to have the opportunity to address to you and have the opportunity to share with you some views on how to integrate online dispute resolution in the current legal system. Please let me just share my screen, because I would like to illustrate some of the ideas today with the following slide, the following presentation. How to integrate online dispute resolution into the legal system? What do we need to regulate, or what can we use from the existing current legal system for dispute resolution? I would like to conduct my presentation around 5 main topics. The first one is to define properly what is the concept of online dispute resolution and the scope of ODR in the context of the broader phenomenon of alternative dispute resolution. Only then we can decide to which extent we need additional principles and additional rules specific for ODR. The second problem that is absolutely coherent and inherent to the alternative dispute resolution is precisely the need of impartiality. And that leads us to discuss ODR platform governance that I will address in a minute. The third topic will be, what are the principles, the rules that we need to implement for the purpose of transforming ODR in an access to effective justice or an effective access to justice. I would like to very briefly make a reference to the use of purely automated decision in the context of ODR, and to which extent we should and we could use artificial intelligence in dispute resolution, and very briefly to conclude with the very important issue of enforceability of these ODR decision. The first very important issue is how to define the perimeter, the conceptual perimeter of online dispute resolution. The COVID pandemic has proved the need of implementing digital technologies and the use of electronic means in the context of either court, so judicial system, but also alternative dispute resolution. But ODR should go beyond that. ODR does not simply define the use of digital technologies in the context of traditional IDR or the judicial system. It's more than that. It's a model that is aimed to produce a singular scheme for dispute resolution in the context of online environment. So as you can see, ODR models could be ODR systems, mechanism, totally isolated or integrated in more sophisticated ecosystem, or we could use ODR linked to the idea of ODR platforms. In all the cases, the main discussion is, are they simply digital version of the existing IDR? They are simply digital arbitration, digital negotiation, digital mediation, or we are trying to produce alternative, purely electronic and digital alternative to this existing classical model for dispute resolution. My proposal is that that should be our approach. Our approach should be to which extent we can start from what we have, but try to leverage and exploit this characteristic and go beyond in producing singular model that we can define as ODR. That leads us to the second problem. If we need to guarantee in dispute resolution impartiality, neutrality, lack of conflict of interest. And we are talking about the emergence of essentially ODR platforms aimed to provide and facilitate service for online dispute resolution. We need to focus on guaranteeing that the ODR platform governance meet this requirement of impartiality, lack of conflict of interest, neutrality, in order to guarantee, in order to ensure that ODR are indeed functionally equivalent of other alternative dispute resolution. Let's focus now on what kind of principle and a specific rule we might need to adopt in our legal system in order to conform a legal framework conducive to the implementation, the development, the promotion of online dispute resolution. In order to imagine what are the principles we need, first, we have to address what are the challenges. Let me please discuss with you very briefly the main challenges that I can see when we try to apply online dispute resolution from this perspective that they are an alternative, innovative model for dispute resolution. If these online dispute resolution are conducted within a platform, an online or digital platform, the main question is, are the internal policies of this platform, the platform or community policies, the procedural rules? Should these procedural rules necessarily coincide and be aligned with the procedural rules applicable to existing alternative dispute resolution? To the extent that in preparing the alternative dispute resolution online dispute resolution, we need to have the parties accessing and joining the platform. Is this a valid consent for the purpose of ensuring that the final decision would be enforceable for the parties? Is indeed the final decision recognizable and enforceable, but enforceable only within the platform? That should be merely based on the obligational, the contractual scheme that all the users of the platform accept, or also outside the platform. That would be indeed the value, the added value of this kind of ODR. But in any jurisdiction as well, do we already have the convention, the treaties, the principle that guarantee that this recognition and enforceability should be also applicable to this kind of decision, even if they are alternative to arbitration, mediation, negotiation? What is the applicable law? If we are in a digital context, there is a clearly lack of territorial connecting factors. So maybe the internal rules of these platforms become the applicable law. Is that a challenge that we have to address? What is going to be the possibilities of the parties to challenge the final decision, to appeal, to get a redress in case that the final decision is not in conformity with the rules, or is simply a disagreement by one of the party that would like to go to an appeal? Now that we can see more or less what are the challenges, what should be the principle that we could figure it out and elaborate in order to promote online dispute resolution? First, clearly, the principle of accessibility, effective accessibility. There is clearly a natural barrier to entry when we talk about online dispute resolution. That is indeed the technological barrier. So accessibility is aimed to guarantee a proper access to online justice, and is based on infrastructure, but also access and also services, software, and indeed all the skills that ensure that the parties are at an equal level. In the context of the operation of this online dispute resolution, all the principles related to evidence, equality of arms, confidentiality should be equally guaranteed in a different environment, the digital environment, therefore with some specificities, but with the same policy aimed at the very end. Explainability. Why I would like to include this element that is becoming a very well-known international standard in the regulation of algorithmic decision-making and the use of artificial intelligence. Because in the context of an ODR, we have additional challenges related to the opacity of the system, the complexity of the systems, the data dependency of these systems. And because of that, the mere transparency, the mere information about the rules, how the system operates might be not sufficient for the purpose of guaranteeing the equal position of both parties or all the parties in the ODR proceeding. So explainability go beyond and try to ensure that all the technical or algorithmic element that should be known by the parties because they are fundamental for exercising their right should be duly communicated and properly explained. That is very much connected with the next principle, particularly when, as we will say in a minute, when we decide to promote and enhance the effectiveness of the system using algorithmic decision-making or artificial intelligence-driven system for the purpose of conducting, facilitating, or even adopting the final decision. Is that possible? It's clearly an opportunity. It's an opportunity that, however, entails certain challenges and certain risk. When the algorithm adopts the final decision, it is fundamental that that is not overriding or undermining the right to a reasoned decision. The possibilities of the parties to understand what are the motives, the reason, the grounds on which this decision, even if purely automated, has been adopted. And that naturally opened the possibility for the parties to claim a judicial review, as therefore they know what are the reasons, what are the motives of that particular automated decision. So let me please conclude by saying, in order to assess to which extent we have to integrate the ODR in the existing rules, or on the contrary, we have to regulate additionally certain principles and rules, the first and main and important decision is to which extent ODR represent simply the digital version of ADR, or on the contrary, they go beyond and they are a singular model, an alternative model to ADR that required a particular analysis based on the following principle that I have been discussing before. Thank you very much.
Thank you very much, Ms. Teresa Rodriguez de las Heras Baliel. Discussing further about regulating online dispute resolution and its relevant law and policies, we introduce our next speaker, Professor Jeannie Patterson. Professor Jeannie Marie Patterson teaches and researches in the fields of consumer protection law, consumer credit and banking law, and AI and the law. She has published widely on these topics in leading journals and edited collections, including as the co-editor with Elise Bant of Misleading Silence. Jeannie is also the co-author of a number of leading textbooks, such as The Principles of Contract Law, Caron's Australian Consumer Law, and Duggan and Lanyon on Consumer Credit Law. Her scholarly work has been cited by courts, including the High Court of Australia and the Supreme Court of Canada. Jeannie completed her Bachelor of Arts and Bachelor of Legislative Law honors degree at Australian National University, or ANU, and her PhD at Monash University. Jeannie is a Fellow of the Australian Academy of Law. She is an editor for Consumer Protection in the Australian Business Law Review and the Journal for Law, Technology and Humans. Ladies and gentlemen, let us all welcome Professor Jeannie Patterson.
Thank you so much for having me, and I'm delighted to be here, and I very much enjoyed the previous presentation, and indeed will be building on some of the themes that were in that previous presentation. Now, I also have some slides which I hopefully will be able to share. I think that I sent them through. Are you able to put them up on the screen, or do you want me to upload them?
Sir, your PowerPoint is loading at the moment.
Thank you so much. And while that's happening, I might just as well start with sort of a general overview. As I think has been mentioned in the previous presentation, there's been great interest in ODR for some time, at least since 2010 and earlier. But the pandemic that we've had has really brought concern about this to the fore. And so there's a lot more attention, I think, being on the possibility of ODR. And the other factor that, of course, has influenced that is just the growth in AI and digital technologies, which makes possible all sorts of things that we previously didn't imagine. So it's a really important topic and the topic of the day. Now, can I move those, or do I need to ask you to move to the next slide, please? Thank you. So I think the themes of my talk are compatible with the last one, but perhaps picking up on that question that was asked by the professor about just how we understand ODR and its relationship with ADR. And what I would like to say that at this point in time, it's really important not to overestimate the capacity of ODR and ODR tools. We often talk about the role of AI in this context, and sometimes we think that's going to be a system that will replace and surpass human decision-making, human judges, human mediators, operating in a way that is superior to and more insightful than humans can do. And what it's really important to remember at this point of time is that when we're talking about digital technology in ODR, generally we're speaking about more than just digitizing documents, but equally we're not talking about superhuman artificial intelligence. We're talking generally about coding rules of thumb or decision-making processes through decision trees, perhaps making use of some data-driven solutions, but that's very much a statistical model. So what that means is when we're thinking about regulating ODR or the way we use ODR, it's important to hold on tight to the values of the systems that we are sort of introducing the ODR to. If it's designed properly and well, ODR can create tremendous advantages in terms of access to justice and also consistent, impartial justice. But done badly, it can undermine the values of the judicial system and also of the aspirations of ADR. So if you can move on to the next slide now, please. So what do we mean by ODR? And I think, as we've just heard, ODR means a number of different things. Initially, it really meant remote access, filing documents digitally, perhaps video links for dispute resolution type processes. And then as the technology became somewhat more sophisticated, we saw increased automation of high volume, low impact processes that might be used in courts and arbitration schemes. So using electronic documents, form filling, digital case files, and online case management systems, but still very much process driven, speeding up the process, but not changing it in any way. At the sort of, as I mentioned earlier, the sort of aspiration perhaps is a fully automated or augmented decision-making system. Now, I don't think we're quite there yet generally, but what we're seeing increasingly is electronic systems or digital systems or AI being implanted into ADR or ODR and playing a genuine role. So we're not at the place of an AI judge or an AI mediator, but we're seeing more than just automation of processes, but this idea of automated decisions or human augmented decisions using AI or equivalent technology. And as I said, that's not the all-seeing superintelligence. It's expert systems or yes, no patterns being put into forms and the like, and some use of statistics and data to drive decisions. So if you go to the next slide, please. So what we want to think about then, I think, when we're implementing these systems is not only is about the compatibility with the legal system, which will depend on the sophistication of the system we want to use, but also the compatibility with those underlying values of the legal system. So generally, the argument for ODR is often cost and efficiency, which of course, as previous speaker made clear, cannot be the only values that we seek in an ODR system. We would like to improve the efficacy and the efficiency of the system because that makes the system available to more people. But, you know, dispute resolution is a public good. It's not just an economic value. So we need to think about the other kinds of values that are important to us in a judicial system. Access to justice, I think, has been spoken to. ODR expands opportunities to participate. We want in ODR to have participation in a just and equitable manner, so people feel that they can present their case and participate in dispute resolution. And we want fairness, transparency, protection of vulnerability. There may be some sorts of situations where people who are in a dispute resolution system need additional support. They certainly need to understand the process that they're subject to, and they certainly need it to be treated fairly in the sense that there's an absence of bias and the like. Now, those are all values of the legal system that we're probably all familiar with and have been embedded in arbitration, mediation, and other forms of ADR for some time. And the question I want to pose to you really at this point is, does the interjection of sophisticated technology into that system change things? Is it just, you know, more of the same, or is it a different type of process in its own right? And my argument would actually be that as soon as we interject sophisticated automated processes or into dispute resolution, then consistently in the way that other authors have commented, it becomes a fourth person. It becomes an entity, it has an impact in its own right. It introduces a certain stickiness into the system, a complexity into the dispute resolution system, which we need to focus on. We can't just sort of gloss over the existence of automated processes in the dispute resolution system. We need to take them seriously in their own right and think very carefully, as was discussed in the previous talk, about their design to make sure that they remain compatible with the legal system, but also don't introduce lots of other problems that arise from automating processes. So if we go to the next slide. So when we introduce digital technologies that are collecting processing information and then making recommendations or decisions, they themselves carry certain risks of harms to the individuals who are involved. So assume, for example, that we introduce a system, perhaps as we see in, say, the British Columbia system or some of the other systems, a sophisticated digital triage system that's automated. So it's collecting information, assisting in the collection of information, assisting in explaining the process to participants, assisting the participants in framing their dispute, and then suggesting settlement and the like to the participants. Assume we introduce that sort of system into our ADR or our ODR system. What are the types of concerns that might arise from the fact of automation? Now, some of those were mentioned in the last talk, and so I'll expand on them a little bit. As soon as we're starting to collect, store, and use data, the privacy issues that arise are amplified from simple in-person processes, but even simple digital processes. So if people are simply filling in a form online and submitting it, there is some concerns about the data that's collected and the privacy implications of that. But the more parties are interacting with the system, the more they're being asked to frame their case or engage in some sort of settlement discussions online, the more and more data has been collected about them. And as we all know, there's capacity for that data to be used for other kinds of purposes that may not be in the interest of the parties. So that question of sort of what is happening with that information, how is it being protected, what steps at anonymisation are being taken become very important. And the flip side of that is data protection. If ODR systems of the kind I'm talking about are collecting large amounts of information about the parties in order to guide them through the process, it becomes very important that we have really secure cybersecurity or data protection around those systems so they don't become honeypots for hacking, leaving the participants very vulnerable. Fairness, of course, we've already mentioned, that's a key judicial value. But what we know about automated systems is that they have the capacity to amplify bias. Now, sometimes that occurs through this idea of the black box, so a machine learning system that's collecting lots of information and using the data that it has to make recommendations or decisions, and perhaps picking up making new correlations that discriminate against certain individuals or groups. Now, that may happen in our automated system if it's using some kind of statistical process to make recommendations, say for dispute resolution or settlement. But bias can also simply be coded into the system. So if we have a expert system that's based on hand-coded rules, the biases that exist in the person who's doing the coding or indeed in the system itself can be amplified. So questions about the assumptions that are being made in managing that triage process I've talked about need to be thought through carefully. Equity is also a value of the legal system, but again, once we automate processes, equity takes on a whole new light. We're well aware in online processes that we need to think about whether people who ask to engage in those processes can get access to the technology. We know they need to have a computer and an internet connection and be able to fill in the form and participate in online hearings. But there's other issues that arise with equity that are a little bit more subtle. Is the form accessible to people that have low levels of literacy? Does any video conferencing work for people that perhaps have unstable internet connections? And those aren't the same questions of equity that occur in the judicial system. They're questions that arise from the fact that we're automating our process through more sophisticated digital technologies, and that those technologies are playing a larger part in the triaging and dispute resolution processing. Do people who are involved in the system understand what's happening? And do they understand what's happening in a way that's meaningful for them, as opposed to some technical and complicated explanation of the algorithm that's being used or the coding that's taken place? And finally, and importantly, and uniquely, I think, to online system is reliability and robustness. So the system itself needs to be accurate and correct. Now, these are all, none of these problems are insurmountable when we're thinking about embedding this sort of hybrid, augmented digital processes in ODR, but they do need to be thought through carefully, and that brings us back to design. The design questions are important, and I think those design questions come before any legal question about how you actually regulate the process. What are we trying to achieve? What do we envisage for the role of our AI system or our automated system? And that really tells us the kinds of interventions we might need to keep those systems fair, safe, and secure. So that's all from me.
Thank you very much, Professor Jeannie Patterson. Ladies and gentlemen, we now proceed to the reaction and panel discussion of our program. To moderate this session, we have Attorney Jared P. Amoroso, the Senior Vice President for Advocacy of the Philippine Institute of Arbitrators, or the PIAR, and an OADR accredited arbitrator. Ladies and gentlemen, I now turn you over to our moderator, Attorney Jared P. Amoroso.
Hi, good morning, everyone. Thank you for the introduction. I am privileged to be your moderator for this part of the program. This is now day 3 of the National ADR Convention. Last Wednesday, you learned about the digitalization of ADR and how it benefits the ADR community, how the ADR practitioners are adapting to new technologies which arise relating to ADR. Yesterday, we tackled the different domestic and international online dispute resolution systems, ODR. Today, we are discussing issues regarding the integration of online dispute resolution into the legal system. So, just now, we have heard excellent insights from our esteemed foreign guests, Professor Teresa Rodriguez de las Heras Baliel and Professor Jeannie Patterson. We will now hear from 3 esteemed members of the Philippine legal profession for their reactions. We have with us today attorneys Teodoro Calao IV, J. Patrick Santiago, and Arleo Magtibay Jr. I will introduce them shortly before they give their reactions, and once they finish giving their reactions, we will invite them back for a short panel discussion. During the panel discussion, we will also take up questions that you, our audience, may have. So we invite you to type up your questions over at Facebook or wherever it is that you are tuning in, and the OADR Secretariat will take care of bringing them to our attention. Okay, for our first reactor, Attorney Teodoro A.Y. Calao IV is the arbitration profession representative of the OADR's Advisory Council. And rightly so, given his numerous credentials and achievements in the field of ADR. Are you ready? Attorney Calao is the first and only Filipino chartered arbitrator, a fellow of the Chartered Institute of Arbitrators with a diplomate in both international commercial arbitration and mediation. He is a fellow of the Asian Institute of Alternative Dispute Resolution, the Singapore Institute of Arbitrators, the Hong Kong Institute of Arbitrators, and the Philippine Institute of Arbitrators. He is the President Emeritus and co-founder of the Philippine Institute of Arbitrators, a trustee and the Sustainability Chair of the Philippine Dispute Resolution Center Incorporated. He is the Deputy Secretary General for Education, Accreditation, and Development of the Philippine International Center for Conflict Resolution Incorporated. He is the newly appointed Dispute Resolution Administrator of the Philippine Wholesale Electricity Spot Market. He is licensed to practice law in the Philippines, New York, and the U.S. Supreme Court, and is a partner in Calao, Prasad, and Hofileña Law. In his spare time, believe it or not, he teaches at the Ateneo Law School. Without further ado, ladies and gentlemen, Attorney Teodoro A.Y. Calao IV. Attorney Teddy, you have the floor.
Thank you, Jared, and good morning, everyone. I only have 5 minutes for my reaction, so I'll keep it short by focusing first on the bad and then the good when it comes to what I think our theme here is integrating ODR with ADR. First, the bad. I think when you look at overall, if I can boil down what we should have reservations about in the coming years about adopting ODR, it boils down to one word, and that is trust. Trust in the sense that I don't see a day when we can actually replace reasoned decision making on the part of individuals like us, except probably in extremely limited cases where relating to very simple documents only arbitration. But the reason why I think ODR will never be replace human administered ADR is really when it comes to the fact that there's just too many processes that I don't think you can put into AI, regardless of how deep or advanced it becomes. And that goes to my second reservation about it. It's contextualized fairness, whether in the process itself, there are just too many considerations. There's just too many, each context every matter that is arbitrated or mediated has too many processes that only individual discretion can cure. That's just one side. In arbitration itself, particularly where parties allow tribunals equity jurisdiction or to decide not just on based on the legal or contractual merits but also fairness, I don't think we'll ever reach that day where, and even if we do, hypothetically, you'll always have that challenge of trust that at the back of your mind, you're saying, would a decision maker or the provider of the award, would the award be better if it were an individual who truly will be able to get into the context of each situation? So that's a bad side, trust. But the good side here, we also have to look at. And if there's one word that I think can summarize the opportunities here, it is leverage. Leverage in three ways. One, process efficiency, not just in submissions. We see that already, or using technology to bridge distances and conduct hearings. Not just that, it's also administering and making more transparent arbitrations in the sense that costs. You can do the logistical part much more easier with technology, and maybe eventually in most cases appointments, provided we have a strong culture of disclosure. I foresee a day where you can automate, given a panel of arbitrators and given factors that they put in as to their experience and so forth, we might be able to even automate appointments as long as we have a strong culture of disclosure. That after you're appointed, if there's something that you felt has been missed, you can disclose for the parties. If you can, provided it's not something that would not automatically knock you out from consideration, or if you should disqualify yourself, as long as we have a strong culture of disclosure, I foresee even appointments becoming automated. One. Second of three, when it comes to leveraging ODR, is the fact that we can greatly enhance decision making going forward. Foresee in terms of using data from previous cases that is protected. So, for example, if there are decisions in a service provider that are very similar, this can be put together, and the arbitral tribunal working on a current matter doesn't have to know who the parties are, or all they have to know is that in previous decisions, an arbitral tribunal may have worked one way or another, and that it might factor into their consideration. It will certainly decide the case for them, but having that kind of data will greatly help enhance potentially the doing and facilitating awards going forward. And of course, third, access to resolution. It's so much easier to have so much information, not just information, but participation online with a service provider or even with an ad hoc tribunal. If you have a platform dedicated to just doing arbitrations, you can have access to resolution. I think will be a great way to leverage ADR through online dispute resolution facilities. So, in a nutshell, what am I highlighting here? Basically, going forward, I think the next decade or two, we will see greatly ADR being enhanced as a facility for leveraging our discipline. I want to highlight that. Facility for leveraging. But it will not and should not be a mechanism to do ADR. It's not going to replace neutrals, but it can be, it's not going to be a mechanism to do, but it can be a facility for leveraging. I think going forward, if we stick to those themes, we'll be all right and we'll have better ADR. Thank you.
Thank you so much, Attorney Teddy. So yun, no? The good and the bad of ODR. Okay. Let us now go to our next reactor. Attorney Teddy, later on, we will invite you back for the panel discussion. So stay tuned, please. Okay. Our next reactor is Attorney J. Patrick R. Santiago. Attorney Santiago, or J, is an independent ADR practitioner based in the Philippines. He is legally qualified in the Philippines and England and Wales, with over 12 years of legal experience in Hong Kong and the Philippines. He has worked at the Hong Kong International Arbitration Center and Kisumbing Torres, which is a member firm of Baker McKenzie in the Philippines, focusing on international commercial arbitration and restructuring and insolvency. Jay is currently the country general counsel for the Philippines and Vietnam of Kyndryl, IBM's spin-off company that provides managed IT infrastructure services to clients around the world. Jay is an accredited arbitrator of the Philippine Dispute Resolution Center, the Philippine International Center for Conflict Resolution, the Philippine Institute of Arbitrators, and our very own OADR. He is the founding co-chair of the Chartered Institute of Arbitrator Young Members Group, Philippine Chapter, and Young Philippine Institute of Arbitrators. Jay obtained his Master of Laws degree at the London School of Economics and Political Science, where he acted as the LSE LLM Arbitration Society Advisor. Jay obtained his Juris Doctor degree from the Ateneo de Manila University, second honors, St. Thomas More Most Distinguished Graduate Awardee, where currently he teaches conflict of laws or private international law. Ladies and gentlemen, a virtual round of applause to Attorney J. Patrick Santiago. Jay, you have the virtual floor, so to speak.
Thank you. Thank you very much, Jared. Can you hear me clearly? Can you hear me?
Yes, I can hear you.
All right,
Jay.
great. Thank you. Thank you very much, Jared. Well, I think this is a very, very interesting topic. There has been a number of talks about online dispute resolution. As mentioned earlier, the UNCITRAL has been looking into this sometime, early 2010, and there have been a number of materials that have been issued by various organizations regarding online dispute resolution. There's always also been a number of efforts here and abroad to, adopt online dispute resolution in resolving mostly commercial disputes. What you can see is that until now, I think it hasn't flowed yet for various reasons, as identified by our resource speakers earlier. But with the advent because of the pandemic nowadays, we've seen that there's been a lot of technological advances on the more traditional forms of alternative dispute resolution. And I wouldn't be surprised that this interest on ODR is again reinvigorated because of the effects of the current pandemic, and again with the resurging interest on the use of technology in resolving disputes. What my reaction would focus on is on the compatibility of ODR under Philippine law. When I first learned about this topic, I was wondering. I don't mean first heard of this topic just recently because of this conference, but this topic has been the talk of the town a few years ago also. And when that was a very hot topic then, I kind of thought whether this can fly in the Philippines and whether our current legal system can support the online dispute resolution. It appears that I think it can be supported by our current law. Our Republic Act 9285, otherwise known as the ADR Act of 2004, provides for referral of a dispute to other ADR forms. Obviously, ODR is a form of alternative dispute resolution because you don't go to court and you get your dispute resolved, outside of courts. So this is obviously something that can be covered by the other forms of ADR under Republic Act 9285. You can have a look at Section 18. Now, under the IRR of RA 9285, specifically Chapter 7, there is also mention of other forms of ADR. Now, what is interesting here is that if the ODR, for instance, can be in the form more akin to mediation, where a neutral third person merely assists the parties in reaching a voluntary agreement, then the rules and laws on mediation shall apply or have supplementary application. If the form of ADR, if the ODR comes in the form of something similar to arbitration, where a neutral third person has the power to make a binding resolution of the dispute, then our laws provide that the laws on domestic arbitration shall apply to, shall have a supplementary effect to that form of ADR. So that is quite interesting, because if you also look at the special ADR rules provide a similar provision. If you look at Rule 18 of the special ADR rules, there is the applicability of the rules on mediation and the applicability of the rules on arbitration to other forms of ADR. Again, if the ODR comes into the form of more akin to mediation, then the rules on mediation will apply. And if it is more akin to an arbitration, where a third neutral party has the power to make a binding resolution of the dispute, then the rules on arbitration under the special ADR rules shall apply. Now, that is quite interesting because even if we're not sure to what extent the rules on mediation and the rules on arbitration can apply to ODR. The ODR can be in various forms. It can be an assistance for the parties to come up with a settlement agreement. The ODR can be in the form of assisting a third-party neutral to come up with a decision later on. Or ODR can be in the form of, on its own form of ADR, where there's no third person who will actually make a decision. It can, for all we know, it can be an algorithm, or it can be not just one third person. It can be it can come in a lot of forms. So under our laws, it appears that provided that there is a neutral third party, it can be covered by our laws on ADR, whether that be under RA 9285 or the IRR or the special ADR rules. But my question now is, what if there is no third party neutral? It's that's quite interesting because our RA 9285 already mentions that other forms of ADR can be covered by RA 9285. So I just wonder whether it was really the intention that the other form of ADR contemplated under RA 9285 actually requires a third-party neutral. Now, provided that we are able to, answer those questions and heard those issues under our laws, I think that there is still an issue in the Philippines. I think in a general sense as well, as to trusting the system. We need to trust the system. Of course, there is a consent. Like any other forms of ADR, the parties must consent to this ODR form, whether that be similar to mediation, arbitration, or a totally different form of ADR. And they can probably manifest that in a traditional manner, like putting it into writing, putting it in their contracts. But the question there is, do you really consent to it when, for instance, an online seller puts in the terms and conditions of its contract that any dispute shall go into this particular organization that will conduct ODR to resolve the dispute between the parties? Is that a consent that is that a form of consent that can be recognized under RA 9285 for other forms of ADR? What is also interesting to know is trusting the system. What if this online seller or any party for that matter provides for a dispute resolution mechanism that will be conducted by an institution, an ODR institution that can be related to it. And this is not unheard of. There is one Russian case where it was an arbitration, and the arbitral institution was actually found later on to be related to one of the parties. It cannot be unfathomable to think of a huge conglomerate or a huge business to set up their own ADR institution, and refer all their disputes to that institution, provided that there is agreement between the parties. And as I said, that can be in the form of an agreement, or that can be in the form of, if there's an invoice and the party agrees to it, there's an implied agreement, among others. I mean, there can be a lot of possible arguments in relation to that. So another issue that was raised earlier would be confidentiality. Because it's online now, as mentioned earlier by one of our speakers, that can be prone to hacking. And and that issue is not even unique to ODR. It is even an issue right now in arbitration and in mediation, because many of these mediations and arbitrations, because of the pandemic, are using online platforms, and they continue to now use the cloud when storing information. So many arbitrators that I've seen are not very familiar with making sure that their information online are protected. But I guess there's a lot of effort now on the part of the arbitral institutions to make practitioners aware of cybersecurity, and so that is a good development. So what I'm saying is, now that we're thinking of online dispute resolution, and we're contemplating a procedure that is mostly, or if not 100% online, then this issue on confidentiality and cybersecurity becomes more of a problem. Those are just some of my comments, but happy to discuss that later on during the panel discussion.
All right. Thank you very much, Jay, for that very insightful reaction. As Jay mentioned, we will also perhaps dissect some of the issues that were part of what Jay discussed during the panel discussion. So again, before we proceed to our third reactor, we want to remind the audience to please send over your questions, type them up at whatever platform you are using to tune in to this program, and then we will take them up during the panel discussion as well. Okay, our third reactor, is Attorney Arleo Magtibay Jr. Attorney Magtibay is the Executive Director of the Philippine Dispute Resolution Center Incorporated. Attorney Arleo is the Chairman of the Secretariat Committee, Vice Chairman of the Committee on Sports Arbitration, and part of the Rules Revisions Committee of the Philippine Dispute Resolution Center. Attorney Magtibay is also the Managing Partner of Magtibay Law. He is an accredited arbitrator and mediator of the Department of Justice's OADR, and he is included in the World Intellectual Property Organization Arbitration and Mediation Center's list of mediators and arbitrators. Attorney Magtibay is a member of the Chartered Institute of Arbitrators and a fellow of the Philippine Arbitration Center in the Visayas. He also served as the inaugural Assistant Vice President for Special Interest Groups, Sports of the Philippine Institute of Arbitrators. Attorney Magtibay obtained his Juris Doctor degree from Ateneo de Manila University and his Master of Business Administration and Bachelor of Secondary Education degrees from the University of the Philippines, Diliman. He is currently studying for a Master of Laws degree with a certificate in Law and Technology from University of California, Berkeley School of Law. Ladies and gentlemen, Attorney Arleo Magtibay Jr., RJ, the virtual floor is yours.
Thank you, Jared, and good morning to you and good morning to everyone. It is always difficult to speak immediately after experts on the field have given their thoughts on the subject. Attorney Teddy and Attorney Jay are undisputedly among the country's best ADR practitioners and experts. So I will just try my best to contribute to this discussion. I know we have a limited time, so I will keep my reaction short and brief. Okay. So during the presentations, one of our speakers stated that in order to assess up to which extent we have to integrate ODR in the existing rules, we need to decide on which extent ODR represents simply the digital version of ADR, or if we should go beyond and treat them as a singular model. So something like an alternative model to ADR, okay, an alternative to the alternative, okay. So our speaker has then proposed that from the existing ODR model that we have, which are digital arbitration or digital mediation, a purely electronic and digital alternative to these existing classical models should be produced, okay. She proposed to start from what are currently available, then to go beyond that to produce a singular model that can be defined as ODR, okay. But before we can address our speaker's proposal, we need to understand the current state of ODR. So please allow me to run through this very quickly, okay. So online dispute resolution, or ODR, as we know, have been defined by some as that class of ADR processes which takes advantage of the availability and increasing development of internet technology. So ODR is to allow the parties to resolve their disputes within the use of electronic technology, okay? So it can take place either entirely or partially online, and it may pertain to disputes that arise in cyberspace, but also those that arise offline, okay? So basically, it is just a set of dispute resolution processes that uses some form of technology or online mechanisms in resolving disputes without requiring parties to be physically present or in the same place. Huh? So while most ODR processes tend to be ones that allow for written submissions only, we know that there is a broad spectrum of ODR services available online, available right now, no? Ranging from some are chat-based mediation programs, online arbitration, or even some have fully automated online negotiation services. Okay, so the selection of an appropriate ODR format may depend on the nature of the dispute and the parties involved. So bottom line is that ODR process should be convenient for the users and not cause any undue accessibility concerns. Okay, so it is said that ODR is most useful when a dispute starts online, such as in buying or selling goods or services online. Since the transaction is already conducted online, the most natural thing to do is to resolve the dispute online. But if there is an appropriate forum to do it. Okay, so given this, again, this is said that there are three main types of dispute classifications within the ODR framework. That would be the business-to-business transactions, business-to-consumer, and the consumer-to-consumer. No? So the B2B, or the business-to-business, refers to disputes, very briefly, that revolve around commercial parties, two commercial parties seeking to resolve a dispute over specific transactions. Okay, oftentimes parties in the B2B tend to be already sophisticated users, and there is generally less concern over party vulnerability, and greater emphasis is placed on the convenience and expertise of the process. Okay, that's first. Second would be the business to consumer. Okay, so with the expansion of e-commerce, largely owing to the proliferation of the online shopping platforms that we are all so familiar with, we see that so often in our social media. The B2C disputes are becoming more common, okay? So these types of disputes are generally low cost but high volume, okay? Oftentimes, it involves parties with unequal bargaining power. So on one side, you have the business, and the other side, the consumer. Then the third would be the consumer to consumer, which refers to disputes involving transactions between two consumers, like in the sale of used items, for example. Again, there are, due to the expansion and advancements in e-commerce, you see these platforms where you can sell secondhand goods, and buy them. So we are seeing more and more these transactions. The buyers and sellers are able to transact through the website or the platform, but aside from providing that platform, the websites are generally, of course, not a party to any dispute between the buyer and seller. That's the general rule, basically. So, but looking at ODR further, I have come up with a quick PMI analysis, or plus minus interesting analysis on ODR. Sorry. Okay, so let's first take a look at the plus, or what would be the advantage of ODR. So as a modern take on ADR, ODR potentially has the advantages of cost effectiveness, speed, and convenience. Okay, so it may be the appropriate option, particularly for low cost, high volume transactions, given that it facilitates for timely, cost efficient resolution to problems where the amounts in dispute may not be sufficiently high that would justify having to resort to the traditional modes of ADR. Okay, so necessarily ODR would also reduce, if not avoid, litigation costs. So this is important to parties who wish to keep the cost down, especially those who are unable to afford the cost of litigation. So ODR, as with generally the concept of ADR, is a flexible, informal, and creative tool of dispute resolution. So it's not governed by strict rules of evidence or procedure. So the proceedings are generally more relaxed and informal than in-person proceedings, including traditional mediation, arbitration, but especially litigation. No? So as with all other traditional modes of ADR, it allows the parties to design or participate in a process which can be molded to suit their needs and encourages consensual rather than the adversarial approach. Okay, so of course, all the other advantages again of traditional forms of ADR over litigation are that we know that are there. So those are some of the pluses that we can attribute to ODR. But aside from looking at the pluses, we have to mind the minuses or the general disadvantages of ODR. Since ODR relies on technology, all parties would be required to have adequate technology to participate in an ODR process. Okay? Parties without adequate technology may be at a disadvantage or unable to fully participate. So in the Philippines, for example, internet connection is still a problem in certain parts of the country, as we would know. So that's a problem, no? Then there is that argument that ODR is a less personal form of dispute resolution, as I understand. Remember, Attorney Teddy highlighted this earlier. So because the parties are not in the same room and often all of the discussions are in writing. So because it is impersonal, it may lead to greater distance between the parties. Okay. So another thing is that given that most ODR involves electronic communication, in fact, most of the ODR processes tend to be ones that allow for written submissions only. It works best where the issues can be clearly stated. But also because of that, parties with difficulties communicating in writing would be at a disadvantage in an ODR process. Okay. So the primary purpose of ODR is to allow the parties to resolve their disputes with the use of electronic technology, right? So, but after the pluses and minuses, let's take a quick look at what's interesting, this time in light of the proposal of one of our speakers. Our speaker proposed that from the existing ODR model, a purely electronic and digital alternative to these existing classical models should be produced. Okay? She shared her thoughts on the challenges to having this, such as coming up with internal policies and procedural rules, issues on obtaining consent, recognition and enforceability of the final decision, including issues on redress and appeal. Okay, so given that, it would be interesting to see how these challenges would be addressed here in the Philippines if we are to adopt our speaker's proposal. Okay, is the Philippines ready for this proposed ODR model? Okay, as it is, the Philippines, as you would know, had its ADR law, RA 876, as early as 1953. But it's only recently that we are really seeing ADR, particularly arbitration, being accepted by the public as an alternative to going to court to settle their disputes. Okay, so as such, it would be interesting to see how quick the new model would be accepted, the new ODR model would be accepted in the country. So our speaker also shared 6 principles to promote her proposed ODR. She mentioned accessibility, quality of arms, confidentiality, explainability, right to reasoned decisions, and the judicial review. Okay, so again, it would be interesting to see how the ADR community in the Philippines, such as the accredited provider organizations, the accredited neutrals, and of course, the Office for Alternative Dispute Resolution would accept this proposed ODR model and to come up with mechanisms to ensure the security of the process, and if it would overcome barriers to entry. Okay, but personally, as far as PDRC is concerned, which we are part of course, Attorney Teddy and Attorney Jay, we are proud to say that we already have an ODR committee, and I know many of them have been attending this 3-day event of the OADR. So to study this matter further and to come up with an ODR mechanism that we can probably use later on. Well, so that's really all for now, Jared, and I think I went over time, so thank you.
No worries, RJ, and that was a very interesting addition to the discussion on this topic of integrating ODR into the legal system. I hope that the audience are still with us. I know that they are still with us. I've been receiving a lot of questions from YouTube and from Facebook. We will take them up shortly during the panel discussion. So at this point, I think we have 25 minutes for our panel discussion. So may I invite back into the virtual room Jay, Attorney Teddy, and RJ for our panel discussion. Okay, welcome back. Nice seeing your faces again. Great
Hello.
reactions from you. And unfortunately, we can't. We won't be joined by our esteemed foreign guests as they have to leave for some other prior commitments, but we will take on this topic of integrating ODR into the legal system further. Okay? Sige, ganito. My addition to the discussion is that, and as Jay has hinted at earlier, there are in fact already several documents tackling this development in ODR. And interestingly, in 2016, finalized in 2017, the UNCITRAL in fact came up with its own technical notes on ODR. The purpose being to serve as guidance for several jurisdictions, several states who perhaps may be looking into legislating or accommodating ODR into their own legislations. And I think I want to open the panel discussion with this interesting description by the UNCITRAL on what it envisions an ODR system would be. So it basically comprises of 3 stages. First stage would be a negotiation stage where the parties, through the use of ODR, will resolve between themselves their existing dispute. The second stage is if the parties do not arrive at any amicable settlement. The second stage is when the ODR platform will avail or appoint a neutral to facilitate discussions between the parties. And if a settlement discussion does not end up in a settlement, there is a third stage, which can be any form of ADR through ODR. Okay, so that is basically the envisioned ODR system by the UNCITRAL. My question is, and earlier, because Professor Jeannie raises this very important question of, does the integration of sophisticated processes into dispute resolution really change anything insofar as the legal system governing dispute resolution is concerned? Okay. My question is this. I know Jay has given his opinion on this. So I will perhaps start with Attorney Teddy and then RJ and then Jay if you want to add anything more. My question is this. In that version of ODR envisioned by the UNCITRAL, there's a first stage, no neutral. Second stage, there is a neutral for facilitated discussions. And then third stage, which perhaps may be some form of mediation, some form of arbitration or adjudication. Would that type of ODR be feasible under Philippine ADR laws at present?
Well, Jared, if since you called me first, I think that ultimately, as long as we see ODR as a facility to conduct ADR, you're going to see major change in positive change because it will greatly facilitate the process if we use it as leverage. Where I have significant reservations is this concept that ODR will become its own form of mechanism to do private dispute resolution, particularly when you put in artificial intelligence. Yes, we can. There will be disruptive change in how we do arbitration and potentially mediation going forward for the better. But I don't see it as a standalone by itself, non-human process going forward because of the what I highlighted earlier. It's the concept of trust. And ultimately, ADR processes involve neutrals because of this high degree of trust that the profession has built. It's very difficult for lawyers to promote that if everything is completely automated. Thanks.
Okay, thank you, Attorney Teddy. RJ, your comments, please.
Yes, I join Attorney Teddy's comment that the trust in the people involved in that dispute resolution mechanism is very important, no? But the question on whether it can work within the Philippine setting, what should be, as with the concept in ADR, as long as the parties are agree to it, number one, and then they have the confidence in the process, then it may work, it could work. But again, we always go back to, especially in the Philippine setting, with the personal relations, seeing the people interactions, is still very important. So how quick or how soon a purely automated dispute resolution mechanism will be adopted is a totally big question mark. No? So, but whether it can be adopted, I mean, it can be accepted. I'm sure it could be. So that's just what I can say for about that, Jared. Thank you.
All right. Thanks, RJ. Jay, before I go to you, and only because you've already made your position clear about this, and something that by now the audience would have realized is there seems to be this drawing of the line between ODR, which doesn't involve the decision-making capabilities of a human neutral, and ODR, which attempts to take the place of that human living and breathing neutral with some sort of AI or some sort of technology to render the decision for the parties. My additional question to you, Jay, is what exactly why exactly do you say that it will be problematic in the Philippine ADR legal system when that third party living and breathing neutral is replaced by an AI?
Mhm. All right. Well, I only say that because if we look at our laws right now, as I mentioned, they actually mention different things. I know that the intention is to clarify things, but they actually mention different things. If you look at Section 18 of the ADR Act, which is the law, it says that for the purposes of this act, the use of other ADR forms shall be governed by Chapter 2, mediation, except where it is combined with arbitration, in which case it shall likewise be governed by Chapter 5, domestic arbitration of this act. So it clearly contemplates the availability of other forms of ADR. And in making that declaration that that other forms of ADR shall be governed by the ADR Act, they gave some guidance on which provisions of the law will apply. But if you look at Chapter 7 of the IRR, it talks about it kind of explains that provision of the law. It provides in Article 7.2 and Article 7.3 that if the other ADR form is more akin to mediation, and there's a definition, and that definition is the neutral third person merely assists the parties in reaching a voluntary agreement. And then there's another one for arbitration. If the other ADR form process is more akin to arbitration, and then that is the neutral third person has the power to make a binding resolution of the dispute, okay, there's that definition. The IRR now suggests that if the other form of ADR that the IRR recognizes is a situation where there is a third party, there's a neutral third person, whether acting akin to a mediator or akin to an arbitrator. And that kind of definition is also found in the special ADR rules. That definition, if you look at Article 18.2 and 18.3, 18.2 and 18.3 incorporates that same definition. Mediation, meaning that there's a neutral third party merely assists the parties in reaching a voluntary decision, and arbitration, that is neutral third party has the power to make a binding resolution of the parties. So it looks like the interpretation of the law itself, based on the IRR and the special ADR rules, that there should always be a third neutral party that is involved in the other form of ADR. Now, in this, in the third form of ODR that we are talking about, it's not similar to mediation. It's not arbitration. And it's possibly, some other people might be involved. That's fine. But it's also possible that there's no third person that can be involved, right? And how do I say this? One example, there's been a lot of talks on the use of blockchain technology in dispute resolution and the use of smart contracts in resolving disputes, meaning that there are a number of mechanisms where a certain thing happened, then it will trigger something that will another consequence, and if that consequence happens, it will trigger another consequence, such that it is possible to come up with a mechanism where the different things can happen. It will trigger several things, and it can lead to a resolution of a potential dispute through those triggering mechanisms in a smart contract in a blockchain technology. So no third parties involved, and still there's a resolution because the parties agreed that the dispute, any dispute, will be resolved through their smart contracts. So it's interesting to see what the other forms of ODR can arise other than the participation of a third party, or it being just an assistance to a mediator or to an arbitrator.
Okay, thank you, Jay. Thank you, Jay. I think Professor Jeannie also gives this cautionary note on when tackling ODR, that people should not perhaps give or overstate the capabilities or the extent at which a dispute resolution can be done through ODR. And I think I'm seeing now that if you go to the extreme end of the spectrum, where even the third-party neutral, the living, breathing neutral, will be replaced by some sort of automated process, then that is the point where we encounter legal challenges, at least in the Philippines. So I think let us dial back to a more simple form of ODR. And the reason why I'm saying this is because now I'm seeing the questions, and the questions really relate to a bit operational aspects of ODR. Okay, so there is this batch of questions which deal with attorney.
Sorry, Jared, before you proceed,
sorry, go ahead.
I think I just really want to highlight the difficulty of determining whether an ODR is in a form that is similar to mediation or something that is similar to arbitration, other than just part of arbitration or part of mediation. Because if it's mediation, then that's fine. If it's arbitration, that's fine. We have our laws, right? But if it's similar to mediation or similar to arbitration, our law still covers that. But we're not sure how the provisions on mediation and arbitration will apply suppletorily to that form of ADR, which is just an ODR, but it's not mediation, not arbitration, but similar to mediation or an arbitration.
Okay, got it, Jay. Thank you. As I was saying, the audience have questions on consent, and in particular, perhaps I can restate it for the panel as this: in an online dispute resolution system, where, for instance, in a usual online selling platform, okay, where the parties click on I agree to the terms and conditions of the online platform. In the event of a dispute that will be resolved through the ODR system of that online platform, is that clicking of the box, ticking of the box, which says that the buyer agrees to the terms, is that sufficient form of consent for purposes of an ADR, although in the form of ODR, under our legal system? Okay, so that's the question. Is that type of consent recognized? Is it a valid type of consent for purposes of conferring jurisdiction, for instance, on a neutral in an ODR system? Would anyone like to take a first crack at that question?
Okay, we'll go ahead, Teddy.
Okay, Attorney Teddy.
I guess we have used jurisprudence to grab on this, but I think it really depends on the context. If you look at agreements relating to the purchase of a $50 consumer item in a C2C situation, I mean, And if there's a dispute, I mean, I don't think there's going to be a problem with that. So it really depends on the context. And I understand from previous jurisprudence, particularly relating to click-wrap agreements. I mean, I think that those things are perfectly won't be a problem, particularly for very small claims. But here's the thing. So maybe I'd like to highlight, if we're going to go really into legal permissibility here. When it comes to facilitating and using ODR to facilitate and leverage the processes of arbitration or mediation, I have no doubt in my mind that this will be allowed because of the strong preference of the state to let parties decide how they design private dispute resolution. And that kind of preference carries on in other fields. 2 decades ago, when the SEC allowed teleconferencing, okay, I mean, that shows that even regulators understand that when it comes to areas like this, the preference is let the parties decide, let them be, respect their autonomy. That area, not a problem. When you go, however, to full automation and making it what the professor said, making it its own brand where you don't have a human, I don't think that'll happen. Whether it's in a evaluative situation like arbitration, because of the trust factor, but even more so in a mediation situation. Unlike arbitrators, they look at the positions of the parties, and basically their choice is to decide. Mediators, however, in the situation of assisted negotiation, it's so important to have that human touch. And you can't do that with a computer. At least for me, you can't do that. As a matter of fact, we have so much problems already trying to gauge emotion with the emails, right? Imagine a computer trying to replicate that. So in my view, I don't think we'll ever reach an era where you'll take out the human factor as to the neutral. And that's basically it from me, from a legal permissibility standpoint. Thanks, Jared.
Okay. Got it. Thank you, Attorney Teddy. My next question, before I check on Jay and RJ on whether they have comments on consent, my next question will have to deal with enforceability of a mediated settlement or perhaps an arbitration award arising out of an ODR. Okay, my next question would be, what are your thoughts? Would there be issues on that? Okay, so that being said, Jay, RJ, do you have comments on the consent issue, which may be inherent in ODR systems?
I think with respect to consent, it's just like any form of ADR in a Philippine context, in the Philippines. If it's really intended to be a mediation, then the laws on mediation would apply. If it's intended to be arbitration, then the laws on mediation will apply. But just like any form of ADR, there should be consent. Now, whether that consent, that clicking is considered consent, meaning the agreement is enforceable, then that's different now, because if it's now ODR in the form that is akin to a mediation, then under mediation laws, you can't force anyone to go to mediation, right? But if it's in the form of an arbitration and it's akin to an arbitration, or it's actually an arbitration, then you can enforce it. But there is also a number of considerations there, whether the mere clicking, did you really understand what it entails, especially if it's something you're not familiar with, right? Or you had no other choice but to click it so that you can proceed with that purchase, right? There's really no consent because you need it, so there's really no opportunity to negotiate it. So I think those are some issues that can arise.
Thank you, Jay. Thank you. RJ, consent, or even on the topic of enforcement of mediated settlement or an award in an ODR?
No, it's really, thanks, Jared. It's really just to add to what Jay said. I think he hit the nail on the head when he said it's whether the person understood the way it was presented. Clicking on something, as long as it can be proven that the person understood what it meant and was not forced to proceed with the transaction by clicking that, then it could be argued that, of course, that would be a valid consent. Again, that's just to add to what Jay said. Now, sorry, what was your other matter? The
Okay,
enforcement?
my other question is, do you envision issues on enforcement of a mediated settlement or any agreement arising out of an ODR system, perhaps an arbitration award if something like that is done through ODR?
Well, number one is as long as the parties' consent to that process is confirmed and it's in place, then that's one less hurdle to to overcome. No? And then, but the other thing that we have to look at would be if we have systems in place right now that would recognize decisions or awards made by AIs or something like that. No. Again, I think that was what Attorney Jay was mentioning earlier on whether this is allowed or recognized under existing laws. Because even if you look at even the definition of an arbitrator and a mediator under the RA 9285, it always refers to a person so and so, a person so and so. So I'm sure there would be creative lawyers there arguing that a person so and so will mean a natural person or someone, not an AI on that argument. So, but other than that, making sure that there is a system that will allow for enforcement, then it shouldn't be a problem if the consent is there. Thanks, Jared.
Okay, thank you. Anyone else want to comment on enforcement before I move on to the next topic?
I think, Jared, as
Perhaps our
I,
last topic.
as I mentioned earlier, if it's akin to mediation or it's akin to arbitration, then the applicable rules on mediation and arbitration shall apply suppletorily. But to what extent will they apply? It's very interesting. So if you have like an ADR, let's say neutral evaluation, right? I don't know, and it's akin to an arbitration because there is third party neutral making a decision for the parties. Do you now enforce it under Rule 13 and Rule 12 of the special ADR rules? So it's very interesting to see how this will apply. And so I think in terms of legislation or even IRR implementing rules, it would be good to have some guidance on how this will apply in practice, because it can get confusing and we need to catch up with the developing technologies.
Okay, thank you, Jay. Attorney Teddy, any further comments, or I can move on to our perhaps last topic? Okay, because we're also running out of time. Okay, there are still a lot of questions here. I think most of them are encapsulated in what we discussed on enforcement and consent issues. One is interesting question, and I think can be our last topic, is how do you, if we were to legislate something on ODR, how do we approach it? Do we approach it? Can we approach it in a way that is, for instance, to carve out, for instance, certain cases? Because Attorney Teddy earlier was mentioning something about for small value disputes, perhaps that will be okay. So it calls into question: would ODR be perhaps more acceptable or more appropriate for certain types of disputes or certain amounts of disputes? And related to that is our audience's question: is an approach where certain types of disputes required to go through ODR an approach that would be advisable or even acceptable under Philippine laws? Anyone? Attorney Teddy, you want to start the discussions again?
Well, if you ask me, if as long as you focus on the pillars of trust on the negative side and leverage on the positive side, I don't see actually a need for significant change when it comes to adapting to technologies that ODR will the onset of ODR will bring us. Why? Because at the end of the day, the foundation is there. If you ask me more specifically, is it more susceptible to smaller value claims? My fearless forecast is that at the end of the day, it will be all about the features of what the technology will provide. And frankly, if there is buy-in, if the parties whether it's a small transaction or a big transaction. If the parties can see genuine value in using the technology to facilitate private dispute resolution in terms of how quick they can do the process, how cost effective, and how efficient from not just from an equity but also from a process perspective. If there's buy-in, whether it's a big claim or a small claim, you're going to get adoption. Will we need for adoption of technology significant changes in legislation? I don't foresee. As long as like I said, you don't replace the human, but we may need for clarification regulations in the current law. Well, as you know, there's a current we are currently trying to revise the law comprehensively, but in the meantime, I think that any regulatory changes we need to make, any new rules we need, we can put it in the implementing rules. So that's where I see it, strictly from a legal regulatory perspective.
Thank you very much, Attorney Teddy. Jay and RJ. Jay first and then RJ.
Well, for me, I think it'll be interesting if the government can issue regulations putting ODR into use in some of their statutory ADR. For example, consumer disputes. The DTI has that mechanism. They already have ADR in those in their mechanisms, but actually putting ODR in there, I think will be useful, and I don't see any issues with them integrating ODR. Now, whether that can be similar to adjudication, arbitration, mediation, it's up to them. They can be as creative as possible. They can come up with an ODR system where there can be like when you call a hotline, if your problem is like this, do this, problem like this, do that, and then you come up with a resolution afterwards, and maybe give the parties 30 days for them to agree. If not, then maybe a third person will decide, also online. That can be another form of ADR that the government can consider. You can be as creative as you can, but I think it will help if we do that online, especially during the pandemic, and especially because in the Philippines we are an archipelago, so it's difficult to move around. So I think we are uniquely placed to adopt some forms of ODR into our system.
Right. Thank you, Jay. RJ.
Yes, very quickly. Okay, so your question, if there's a particular industry or where we can start it, if we have to, I would suggest doing it for the low-cost, high-volume transactions, so especially those online disputes that start online, such as in buying and selling goods and services, because these parties are already online, and since they are able to transact online, there is at least that assurance that they somehow know how to operate things online. No? But Jay mentioned earlier, DTI has mechanisms in place, and I believe that they're also already exploring the ODR function, because I know one of our committee has already met with the DTI about that. So that's something that that we can start with just when, and then when it becomes accepted, then we can move on to bigger things. No? So I guess that's one way to start it, to get the ball rolling. Thanks, Jared.
Okay, thank you, Attorney Teddy, RJ, and Jay. Unfortunately, that is all the time that we have, actually. Hopefully, we were able to impart how online dispute resolution is an exciting development, which offers a ton of opportunities for the ADR community, one which we hope would be embraced in the Philippines. Baby steps, ika nga. Once again, this is Jared Amoroso, your moderator for today's panel session. On behalf of our esteemed guests and reactors, I would like to thank the excellent team behind the OADR for giving us the opportunity to participate in this event. Thank you, and I will now turn you over back to our friends at the OADR.
Thank you very much for that informative and engaging exchange of insights and information. Ladies and gentlemen, before we proceed to another interactive session on ADR Intermission from the UST Salingawi Dance Troupe, featuring their performance of a folk dance, Janggay and Pangalay Hapatong. Janggay is a Muslim folk dance from the Bajau tribe. Women perform this celebratory dance wearing long metal or brass fingernail extensions. Like Janggay, Pangalay Hapatong is also a Muslim folk dance originating from Sulu. Hapatong represents the colorful Vinta boats seen along the Sulu Sea. In 2019, the UST Salingawi competed in the 33rd International Golden Karagus Folk Competition in Bursa, Turkey, and performed Janggay and Hapatong for the competition's opening night. Ladies and gentlemen, we bring you the UST Salingawi Dance Troupe. Thank you very much, UST Salingawi Dance Troupe, for that spectacular performance. Taking this momentous opportunity, we would like to acknowledge our partners in the ADR community who have been actively pursuing with us the advocacy of institutionalizing the preferential use of ADR in resolving conflicts. For this interactive session with the OADR accredited ADR provider organizations and practitioners, we call on the OIC Director of the Training, Accreditation, and Promotion Service of the OADR, Attorney Ali Lorraine V. Manrique.
Good day to everyone. I would like to thank all our guests ever since day one. of this convention. Thank you for accepting our invitation, and to all our participants, thank you for staying with us throughout this 3-day convention. At this juncture of this convention, we would like to introduce to you our partners in providing ADR services to the government. In line with Republic Act 9285, or the Alternative Dispute Resolution Act of 2004, and Department Circular 98, or the Implementing Rules and Regulations of RA 9285, the Office for Alternative Dispute Resolution, or the attached agency under the Department of Justice, has the power to provide guidelines on the accreditation and certification of ADR practitioners and private ADR provider organizations. So with us in this session are our partners, are our accredited and certified partners. So I will be introducing the representatives from these organizations, and they will be giving you a brief background on their organizations. So first off, let me call on Attorney Don Mark Calimon, Chairman of the Philippine Institute of Arbitrators. Attorney.
Good morning, Attorney Ali. Can you hear me? I just want to make sure.
Yes, Attorney. Okay. Can you give us a background of the Philippine Institute of Arbitrators?
Sure. Thank you very much, Attorney Ali, for this opportunity. When I was invited to talk about the Philippine Institute of Arbitrators for this morning's event, I was asking myself how best it would be to, I guess, introduce the organization and what benefits there will be to joining the organization. But then over the course of these last 3 days, I've seen that many of the officers of the Philippine Institute of Arbitrators had been involved in the most of the discussions that were held during this NADRC. And I think that speaks very well of how far the Philippine Institute of Arbitrators has come insofar as promoting arbitration in the Philippines. It was in the year 2007 when the Philippine Institute of Arbitrators was incorporated. And there were 5 of us who started the organization. And I'll mention the names of the founding officers later on. But since 2007, we've, from my perspective, we've come a long way insofar as trying to achieve the objectives of the organizations is concerned. I remember the first event that we organized was a training for the Office of the Solicitor General, and this was in collaboration with the Chartered Institute of Arbitrators. So after that, we had a memorandum of agreement signed with the OSG, and then thereafter, several other significant milestones had taken place insofar as the Philippine Institute of Arbitrators is concerned. We are a member of the Regional Arbitral Institutes Forum, a regional organization of arbitral institutes which organizes annual conferences, even during these last 2 years when the pandemic was at its height. Then we've also collaborated with various arbitral organizations and institutions in providing trainings and seminars to our practitioners in the Philippines. So we've held almost on a monthly basis various lectures on arbitration and ADR, and in many instances have collaborated with institutions like the HKIAC, SIAC, PDRCI, our local arbitration center, PCAM, the Institute of Construction and Arbitrators and Mediators, and so many other activities. One of the more important activities that the Philippine Institute of Arbitrators was involved in was actually a collaboration with the OADR. Around 2 or 3 years ago, we were exploring possible amendments to the ADR Act of 2004. And with the renewed vigor that the OADR has been showing over the last couple of years, I'm hoping that we will still be able to improve and update the ADR Act of 2004. And of course, the Philippine Institute of Arbitrators would be very much happy to assist in whatever way it can to revise and update our arbitration law. And then just before the pandemic, and I wanted to mention this because this is really something that the Philippine Institute of Arbitrators had been hoping for, and I can see that the OADR is already, I guess, spearheading this particular initiative. The Philippine Institute of Arbitrators have always wanted for the Philippines to have an annual celebration of ADR. So we know that other neighboring countries like Hong Kong, Singapore, Malaysia, they all have arbitration weeks, annual arbitration weeks. And in 2019, so the Philippine Institute of Arbitrators, in collaboration with other organizations, organized the Philippine Arbitration Day. And it was, from our perspective, very successful. Almost all arbitral organizations, including the OADR, were fully supportive and participative. And now, notwithstanding the pandemic, we're very happy to see that the OADR is continuing this and has picked up on this and has started holding, even virtually, this NADRC. So with that, although my instruction was to promote our organization, I really feel that what is more important is to just explain and share what the objective of the organization is. We're not an arbitral institution, so we do not administer arbitration. So we're not competing with arbitral centers like HKIAC, ICC, or SIAC, or even the local arbitration centers, PDRCI or PICCR. But what we hope to be able to do is really to promote arbitration in the Philippines. And I guess I wanted to end this short presentation with a challenge rather than, or in addition to promoting the organization. I would like to pose this, I hope, not too radical challenge to everyone who is participating in this session this morning. Arbitration in ADR is a very popular dispute resolution mechanism insofar as interest of practitioners are concerned. But the reality is, and from my perspective, the sad reality is, no one is, at least not enough people in the Philippines are really using arbitration in ADR. If you count the number of arbitrations being commenced every year, it's very much less than the arbitration proceedings that are being conducted in other jurisdictions or being commenced in other jurisdictions. It's sad because the purpose of ADR is really to help our judicial system declug the court dockets. But we're not so far achieving that objective. This is not to downplay the efforts, the extraordinary efforts of the people who are working behind promoting arbitration. But I guess the challenge is still there. We need to continue these extraordinary efforts to promote arbitration in the Philippines. And I guess it is in that light that I would like to acknowledge and recognize the officers of the Philippine Institute of Arbitrators, because notwithstanding the tasks, I mean, the difficult task of promoting arbitration in the country, notwithstanding the pandemic, and notwithstanding the fact that all of the members and officers of the Institute are all voluntary, not receiving any compensation for their efforts, their commitment and hard work are still there. So I would like to acknowledge at least the current leadership of the Philippine Institute of Arbitrators, beginning with our very hardworking president, President Jesusito G. Morales, and our trustees, attorneys Ricardo Ma PG Ongkiko, Zenaida P. Onquico Acorda, Julius Anthony R. Omila, Janil Jared P. Amoroso, Ian Ray P. Malilom. I mean, there are so many other officers of the Philippine Institute of Arbitrators. Let me also mention our Institute Treasurer, Camille Bianca Gatmaitan, and our Institute Secretary, Daniel Joanna Gaite, our hardworking SVPs, NVPs, Jeffrey Constantino, J. Patrick R. Santiago, Jonas Castro, Joclyn, Luis de la Paz, Ryan Malit, Christopher Purisima, Jan de la Pasión, Mai Liao, Mary Christine Florete, Marilisa Calao, Michelle Loretta, Luisa Dominique Mauricio, Fidel Maximo Diego, Mariel Malyonga, Jess Nicole Santos, Sarah Season, Asuncion de Leon Omila, Carla Pingul, and Jerome Canlas. So I would like to acknowledge and thank them for their hard work over the last couple of years. So Attorney Ali, I hope I did not exceed my time too much.
Yes, Attorney Don Mark, thank you very much for that introduction. I would just like to ask you to stay because I have a couple of questions that I think most of our viewers has for our ADR provider organizations. Thank you, Attorney, and
Sure.
I'll call you later. Now we move on to our next organization, the Conflict Resolution Group Foundation Incorporated, with its head, Executive Director Mia Teresa Corpus. Miss Mia, can you give us a brief introduction of your organization? Thank you.
Hi, Attorney Ali. Good afternoon. Good afternoon, everyone watching this ADR convention, and congratulations to OADR for such a successful event. And I see that many people have tuned in, no, in this virtual platform. So essentially, I'm here to talk about the Conflict Resolution Group Foundation, or the CORE Group. We've been around in the ADR sector for 20 years, actually 21 years already, no? Matagal na. So it was started by the late Annabel Abaya, when she spearheaded the mediation program at the Supreme Court, no? Where she handled the first 400 mediators, no? The training for that. And then after that, we moved on to different agencies in government, followed by Department of Justice, NLRC, the IPO, the DTI, and so many different government organizations. So I think now we've worked with over 5,000 mediators already in the various government agencies, and maybe working with maybe 100 or so government agencies, and in helping them develop mediation process in their as part of their public service. So that's really the advocacy of the CORE Group from 2 decades ago, from when it started, was really to provide an opportunity for our Filipino people, for the public, to have access to justice, access to dispute resolution processes that are cost efficient, that are durable, that involve the human process, that consider the human emotions. And you were talking about this in the previous session, no? You were talking about emotions and the complexity of human beings in addressing conflicts, and this is what we focus on, when we do our work with the CORE Group. That is why in the 20 years that we've been working with different agencies, we've come to develop our own brand of what we call transformative mediation. I don't know if I can actually share. Is it possible for me to share? Wait, to share the slide. Let me just do this. Okay, so they're sharing the slide. So these are the government agencies that we've worked with already, no? Medyo nasira yung ano, but then that's fine. So can you move to the next slide, please? Okay, so this is called the values-based mediation program. So it's a transformative kind of mediation process where, you know, of course, interests are important in mediation, but we go beyond the interests and look for the common humanity, you know, the shared values among all of the individuals that are involved in conflict. And we found this to be something that has been really, you know, transformative and really, when it comes to resolution of conflict, it's very durable, and it really impacts, you know, every human being involved in the conflict in a different way. You know, next slide, please. Yeah, so this is the framework that we've created, the PAJOS. So those of you watching who have attended our program are familiar with the PAJOS framework. No? So coming from all of the years that we've worked with, you know, thousands of government agencies and government employees. This is the framework that we've offered for them, the PAJOS framework. No? And in terms of the statistics, about at the very minimum 90%, you know, of all of the cases have been resolved using this framework. Okay. Next slide, please. Thank you. So we've also developed, you know, this process of understanding the human side of dispute resolution. That is why we developed a process in our trainings called the Circle of Humanity. So we begin all of our programs, with a lot of self-reflection, self-awareness. Ano ba talaga ang role ng mediator in a dispute resolution process, and how do you convince, or how do you encourage parties, you know, to come together and be willing enough, to begin the process of finding the solution to their issue. So we've gone through processes of we've gone through research, scientific research. We've done studies on the physiology and psychology of conflict and bringing in these concepts into the mediation practice. Okay, thank you. So yeah, so I would like to really thank all of our partners, in the last 20 years for working with us and trusting us, and really doing your part in promoting dispute resolution. So I guess that's the 5 minutes. So I just wanted really to congratulate OADR and the entire ADR community. And we have a long way to go. There's a lot of work to be done. But I think by all of us working together in uplifting the profession of mediation and of course arbitration and all the other ADR mechanisms, we will be able to mainstream this service and offer it to more people in the coming years. So thank you.
Again, I'll have a couple of questions later, and I'll be asking them later. So please stay tuned. At this juncture, I will now call on another partner organization, the Philippine Institute of Philippine Institute. The Philippine International Center for Conflict Resolution. So we have with us their Assistant Corporate Secretary, Attorney Jacqueline. She's been with us in a lot of activities for this year. So Attorney Jacqueline, can you introduce us PICCR? Thank you.
Thanks so much, Ali. It's quite a mouthful, so we fondly call it PICCR. So good day, everyone. It's my privilege to introduce to you today the Philippine International Center for Conflict Resolution. It all began with a vision of the Integrated Bar of the Philippines that paved the way for the creation of the PICCR. Mindful of its fundamental mandate to elevate the standards of the legal profession and to improve the administration of justice in our country, vis-a-vis the untapped potential of arbitration and other ADR mechanisms, and realizing that its nationwide network can be further maximized to provide efficient and effective dispute resolution services with the help of its various regions and chapters, the Integrated Bar of the Philippines took up the challenge of finding a way to promote the use of arbitration and ADR and make it a more acceptable dispute resolution mechanism in the Philippines. Thus, the 23rd IBP Board of Governors established the PICCR, a non-stock, non-profit arbitral institution that provides commercial arbitration and other ADR services and facilities for parties to disputes, and creates opportunities for professional training, development, and accreditation of advocates and practitioners. Today, the PICCR administers arbitrations to resolve and settle disputes, whether international or domestic, between parties, whether foreign or local. As an arbitration and ADR center, the PICCR strives to make arbitration and ADR a mainstream option for dispute resolution and seeks to ensure that cost-effective and efficient commercial arbitration and other ADR services are available to parties who find themselves involved in a dispute. With this objective, the PICCR utilizes the IBP's nationwide network to make arbitration and other ADR mechanisms more accessible in the Philippines. To achieve its goals, the PICCR has formulated a set of arbitration rules that incorporates the best practices of international commercial arbitration as developed by world-renowned institutions and include provisions on multiple parties, multiple contracts, joinder, consolidation, early dismissal, emergency arbitration, and expedited procedure. Our fee structure, model clause, required forms, redress mechanism against arbitrators, guidelines for video conference hearings, and online filings procedure are all available on our website, www.piccr.com.ph. The PICCR's reach is truly nationwide. In addition to the facilities of the IBP's regions and chapters, the PICCR has its headquarters at the IBP main office in Ortigas, Metro Manila. While currently all proceedings are purely virtual, we are ready to make available to parties several hearing and breakout rooms once face-to-face proceedings are safe. The PICCR is proud of its robust roster of accredited neutrals, and it is our honor to count several legal luminaries, including retired Supreme Court justices among our ranks. Education and training is at the core of the PICCR. The PICCR provides intensive and effective training courses for interested arbitration and ADR practitioners with the objective of making the Philippines a competitive hub for arbitration and ADR in the region. The PICCR regularly conducts accreditation courses consisting of 3 modules as follows: Fundamentals of Commercial Arbitration, the PICCR Arbitration Rules, and Writing Arbitral Awards. Participants undergo assessment during each of these modules and for the purpose of qualifying them for the subsequent modules. The PICCR's accreditation course seeks to ensure that accredited arbitrators will have the necessary knowledge, skills, and expertise to be effective and proficient arbitrators and/or ADR practitioners. Finally, we engage and collaborate with different chambers of commerce and industry associations to create a continuing discussion about arbitration and ADR in our bid to promote it as a mainstream option for dispute resolution. The PICCR raises awareness among end users of the benefits of arbitration and other forms of ADR. This coming year, the PICCR is eager to continue collaborating with and participating in the activities of the OADR and the IBP, and to further tap IBC's resources and nationwide network to promote and facilitate the use of arbitration and other modes of ADR. Again, we thank the OADR for this opportunity to introduce ourselves, and congratulations for this highly successful second National ADR Convention.
thankful to PICCR. I'm sorry. I was so nervous for introducing you. Attorney Jock is one of our very supportive arbitrators. In one of our webinars before, we partnered with PICCR, also with other APOs. So may I now mention our next APO, which is the Philippine Dispute Resolution Center Incorporated. With us today is their Executive Director, Attorney Arleo Matibay. Attorney Arleo.
Good afternoon.
Yes.
Can you? Yeah. Hi.
Attorney Arleo. He's with us during the panel discussion later, but now he's with us to introduce PDRCI.
Okay. Thank you. Thank you, Penny. First of all, the Philippine Dispute Resolution Center Inc. would like to congratulate the OADR, led by its very energetic Executive Director, Attorney Irene de Torres Alogok, for this very successful National ADR Convention. Thank you for inviting PDRCI to be part of this event, and we would like to take this opportunity to renew our commitment to support the OADR in all its efforts and activities to promote ADR across the country. Okay, so good afternoon again to all of you. It is my honor to introduce to you the Philippine Dispute Resolution Center Incorporated, more commonly known as PDRCI, which continues to lead the way in Philippine ADR. PDRCI is a non-stock, non-profit organization incorporated in 1996 out of the Arbitration Committee of the Philippine Chamber of Commerce and Industry. It promotes and encourages the use of arbitration, mediation, and other alternative modes of settling commercial disputes, and provides alternative dispute resolution services to the business community. Since its incorporation, PDRCI has worked closely with the three branches of government in drafting substantive and procedural rules on ADR, as well as in information dissemination and training on matters concerning ADR. This year, PDRCI is celebrating its 25th year anniversary. To mark the start of this year-long anniversary celebration, PDRCI just launched this Monday the new 2021 PDRCI arbitration rules. Okay, so but instead of telling you more about PDRCI, I would like to invite you to watch this short video on RCI and its new arbitration rules. Could I request the video to please?
25 years, PDRCI has provided quality ADR services to the Philippine business community. From its early beginnings as the Arbitration Committee of the Philippine Chamber of Commerce and Industry, PDRCI was incorporated as a nonprofit organization in 1996. PDRCI advocates the use of arbitration and mediation, as well as other modes of alternative dispute resolution, in settling commercial disputes, both domestic and international. It offers ADR training and accreditation, holds seminars and workshops, administers PDRCI arbitrations, and assists in ad hoc arbitrations, appoints ADR neutrals, and provides a host of ADR services. Its members come from all sectors of the professional, business, legal communities, and more. As the country's leading institution in commercial arbitration, PDRCI sets high standards in service, efficiency, and innovation. In pursuit of this, and to adapt to current and emerging trends in arbitration, PDRCI introduced improvements in the rules on commencement of arbitration, conduct of arbitration hearings, assistance to arbitral tribunals, promotion of transparency, and mechanisms to reduce the time to settle disputes. To jumpstart arbitrations, new model clauses have been added, and new rules and revisions have been made on intervention of parties, representation of parties, nomination and appointment of arbitrators, termination of mandate of arbitrators, and guidelines on fees. To streamline the arbitral procedure, case management conferences now allow a procedural order or terms of reference, depending on the parties and the tribunal. After the statements of claim and defense are submitted, the tribunal may issue supplemental terms of reference to identify the issues to be decided on the merits. In addition, new articles defining the functions and responsibilities of arbitration assistants, such as file counsel and tribunal secretary, have been added. These arbitration assistants will ease the work of the institution and the tribunal and increase efficiency in arbitration proceedings. To maintain the integrity of arbitral proceedings, PDRCI has enhanced its procedures and added new rules on data privacy, third-party funding, discovery and production of evidence, and the publication of summary of awards. To shorten the time to settle certain disputes, the rules improved the provisions on emergency arbitration and expedited procedure and included a provision on summary disposition to make sure that disputes are settled fairly and quickly. Download a free copy of the 2021 PDRCI arbitration rules at pdrci.org. As PDRCI celebrates its 25th year, it continues to innovate the practice of arbitration and mediation in the country, breaking new grounds in negotiation, expert determination, online dispute resolution, and other forms of ADR in specialized fields such as sports, banking, maritime, and many more. As it transitions into the next 25 years, PDRCI remains a trusted partner of the business community and a reliable appointing authority for all commercial disputes seeking alternative dispute resolution. PDRCI, leading the way in Philippine ADR.
So thank you. To know more about PDRCI or to download a copy of our rules, please visit our website at www.pdrci.org. Aside from our 2021 PDRCI arbitration rules and the PDRCI mediation rules, you will also find on our website the PDRCI sports mediation and PDRCI sports arbitration rules. We are proud to say that these two rules for sports-related disputes are the first and only ones of its kind offered in the country, and in fact, even in this part of the world. No? So aside from our website, you may also get in touch with us through our social media accounts on Facebook, LinkedIn, Instagram, and Twitter. So once again, congratulations to the OADR for this very successful National ADR Convention, and good afternoon.
Thank you, Attorney Arleo. I know PDRCA recently launched your rules. I think that was last Monday. And I know Attorney Arleo is also one of their sports arbitrators. So thank you, PDRCI. Now we move on to our next partner organization. With us today is Mr. Kiefer C., the Program Assistant of Mediators Network for Sustainable Peace Incorporated. Hi, Kiefer. Good day.
Hello, good day po. Thank you. First of all, we'd like to extend our congratulations to OADR for this convention. So MedNet was born out of two initiatives. MedNet, by the way, stands for the Mediators Network for Sustainable Peace Incorporated. And it was born out of two initiatives that were supported by the Asia Foundation. The first engagement was in 1995 to 1996 when the Community Organizers Multiversity, which was formerly known as CoTrain, coordinated with the Department of Agrarian Reform and successfully implemented a training project on mediation as an alternative means of resolving agrarian disputes. And then the second initiative was a partnership engagement in 1997 to 1998 between the Department of Environment and Natural Resources and Tanggol Kalikasan to explore the application of appropriate alternative dispute resolution processes or mechanisms in conflicts related to environment and natural resources. And eventually, the key players of both these initiatives came together and consolidated their experiences and learnings in dispute resolution, which led to the founding of MedNet in November 26 of 1999. So to give you more information about MedNet, I'll be showing you a 5-minute video. Can I share my screen? Okay.
The Mediators Network for Sustainable Peace Incorporated is a network
of individuals and professionals that uphold and promote the principle of empowering dispute resolution or dispute management processes in conflicts on land tenure, natural resource, and inter- and intra-organizational disputes involving or affecting marginalized sectors and other key stakeholders. Established 20 years ago as a network of conflict resolution practitioners, MedNet focuses on agrarian, environmental, natural resource, urban housing, ancestral domain, REDO, and other community disputes, offering services such as conflict analysis and conflict mapping, facilitation, negotiation coaching, and mediation. The network's lifetime mission is to promote EDRMP to different sectors with due consideration to the existing dispute resolution practices of indigenous communities. It envisions itself as an institution that contributes to the forging of a successful nation where justice and peace exist and democracy and ecological balance reign in the community, where gender-sensitive and competent conflict managers are proactive in the resolution of disputes, and where a stable network of support and EDRMP practitioners collectively work towards sustainable peace. MedNet's goal is directed at mainstreaming EDRMP as a viable approach to resolving community disputes. MedNet conducts training courses that revolve around topics that aim to sharpen the knowledge, skills, and attitude of an individual in facilitating negotiation processes. The organization offers 4 courses on EDRMP training, namely, the nature and dynamics of conflict and nonviolent communication, conflict mapping, mediation approaches, and healing and reconciliation. The courses on nature and dynamics of conflict and nonviolent communication, as well as on conflict mapping, aim to familiarize MedNet partners on the nature of conflicts, EDRMP features and approaches, conflict diagnostic tools or CDT, and nonviolent communication. The Mediation Approaches course exposes the participants to the interest-based, narrative, harmony-based, and transformative mediation approaches. The Healing and Reconciliation course focuses on reflection sessions on the concepts of healing and reconciliation and invites participants to look at international and local practices. By the end of all the 4 courses, participants are expected to help resolve conflicts in their communities and promote local conflict resolution mechanisms. There are samples of actual cases where MedNet facilitated their mediation practices on. These are: first, the Angat Watershed Forest Reservation case, which is about the mistreatment of the natural resources of the said watershed. After thorough research and data gathering, MedNet recommended a facilitated dialogue between the residents and the National Power Corporation to offer an alternative livelihood for the residents of Barangay San Lorenzo. The second case is MedNet's intervention on the proposed Pulangi 5 hydropower project in Malaybalay, Bukidnon. The conflict map identified the data problems on conflicts on relationship, value conflicts, structural conflicts, and interest conflicts. After information drives, gathering endorsements, recognition of opposing groups, surveys, and communication among stakeholders, concerns were raised and attended to, later canceling the project. These are just some of MedNet's successful conflict resolution experiences. By continuing the mediation practice, MedNet hopes to contribute to sustainable peace in many more communities. The success of MedNet relies on their partner organizations and participant mediators and how they are going to use the knowledge and skills that they've acquired during their training. By applying all of these to their respective communities and organizations, not only will the principles of EDRMP spread widely, but peace and harmony amongst the citizens of our country will also be sustained. Let us create a better and more peaceful community by working together and provide the following generations a peaceful nation to live on.
Thank you, Kiefer, for that introduction of MedNet. We have a couple of questions again later. I will call on you to share your experience of MedNet with OADR. Now we move on to another provider organizations in mediation. We call Ms. Geraldine Bernardo, the Senior Vice President for Advocacy of the National Center for Mediation. Hi, Geraldine.
Hi, Attorney. Thank you for inviting us. It is my personal honor to be here with everyone involved in the ADR movement. So I guess I can consider PDRCI as our sibling because we have the same mother, so to speak, the Philippine Chamber of Commerce and Industry. So when PCCI decided to bring us together and other organizations to set up the National Center for Mediation, or the NCM, we envisioned that by promoting ADR, we can help improve the competitiveness of local businesses, particularly the micro, small, and medium-sized enterprises, or the MSMEs, which comprise around 99% of our registered firms in the country. So we recognize that disputes significantly affect the viability of the MSMEs, as these translate to lost opportunities, lost revenue, increased costs of doing business, and damaged relationships with our suppliers, customers, and partners. So for the MSMEs, the impact is more pronounced, as they normally find it hard to bear the cost of litigation. Furthermore, MSMEs do not have the resources to challenge larger companies in court, and therefore ADR would be a more cost-effective alternative to settling disputes and a way to preserve relationships. So the pioneers of NCM include Sergio Ortiz Luis Jr. He's the PCCI Honorary Chairman Treasurer and Director for our Corporate Social Responsibility. He's also currently our NCM Chairman, together with Ms. Alegria Bingling Hoko, who is our current PCCI Chairperson. So the creation of NCM was done in partnership with the core group, and we heard Ms. Mia earlier from the Conflict Resolution Group Foundation, together with a group of conveners that include the Philippine Exporters Confederation, the ECOP, or Employers Confederation of the Philippines, the Federation of PhilChai, Filipino Chinese Chamber of Commerce and Industry, the MAP, or Management Association of the Philippines, as well as the People Management Association of the Philippines. So a covenant was signed by the heads committing that they shall, number one, actively pursue the promotion and use and development of ADR among the business sector. Number two, strongly advocate our members to state in all their contracts the ADR clause. Number three, push the establishment of business ADR units to be composed of trained professionals, dispute resolvers to address the needs of the business sector, and of course to lead in increasing public awareness and acceptance and use of ADR in the Philippines. So NCM was formally registered with SEC on November 2007 as a non-stock, non-profit association. And NCM has been accredited, thankfully, with the DOJ OADR as an APO, ADR provider organization, I think last year. And we have a roster of over 100 trained mediators nationwide. However, when the pandemic reached the country, our advocacy for increased use of ADR became more urgent and even critical for the survival of many MSMEs. We all agree that the magnitude of disruptions to the business sector has been unprecedented, and these effects we still feel today. Enterprises have taken the burden of supporting their employees during the lockdown period, and even as we go back to Alert 2 and we have opened up a bit, majority are still not fully operational because of all these restrictions and the specter of more variants to come. Now, PCCI and the NCM believe more than ever that ADR, such as mediation, has become more important during these difficult times. Mediation as a much faster, less costly, more effective way of resolving disputes through a transformative values-based and interest-based process that seeks win-win, a win-win scenario and a way to preserve relationships. So we continually encourage local chambers, negosyo centers of the local government units, cooperatives, and other associations and institutions to partner with NCM and offer mediation as a regular service to the business sector and the community at large. NCM will make use of available technologies such as digital or online platforms to make its services readily accessible despite the quarantine and other health-related restrictions that may be imposed from time to time. So again, we thank you for this opportunity to be part of this momentum event. Congratulations and mabuhay.
Yes, thank you, Geraldine. Now we move on to our next provider organization, the Philippine Arbitration Center in the Visayas, a new organization outside of Luzon. So we have with us the founding partner of PACV, Attorney Jonar Pueblo. Attorney Jonar.
Hi,
Jonar?
Attorney Ali.
Yes, okay. Now we can
Good to
hear
meet
you.
all of you.
Thank you.
Can I have my slides so that I could introduce the Philippine Arbitration Center in the Visayas? Next slide, please. You have to understand, we from the province, no, really appreciate what the OADR is doing right now, because you have to understand how hard it is to learn ADR if you are not from Metro Manila. No, so with what the OADR is doing right now is highly appreciated. And while at the time when the OADR is not as active as it is right now, we from the Visayas, and especially in the Panay region, Region 6, needed to do something, and that's why we created the Philippine Arbitration Center in the Visayas. So it was incorporated in 2015 at the University of San Agustin College of Law. It is the first school-based arbitration center in Southeast Asia. There are no other school-based arbitration center in the whole Southeast Asia, not in Singapore, not in Malaysia, and other Southeast Asian nation. We are also proud to say that we're the first arbitration institution outside of Metro Manila. And our office is at the PACV office at the University of San Agustin, General Luna. Next slide, please. So PACV promotes and encourages the use of arbitration, mediation, and other modes of avoiding or settling disputes, and provides alternative dispute resolution services to the business and academic community, especially in the Visayas and the other regions in the Philippines. It intends to build up ADR awareness, especially in the Visayas region, starting from law students, in hope that these law students, after passing the bar, will have a strong facility to encourage and practice ADR. It also acts as a laboratory for law students and practitioners to understand how an ADR institution works, at the same time learning how ADR is in general. Because ADR is not, again, a popular concept in the regions. It's now building into a snowballing in awareness. But when we started, you will be hard pressed to practice ADR if you are from the regions or if you are from the provinces. And that's why what the OADR is doing right now, of making ADR or the ADR awareness open not only in Metro Manila, but also to other regions, Region 6, Region 7, Region 8, Region 9. It's really amazing, and it's really highly appreciated. Next slide, please. So our mission vision is helping bring awareness of ADR to the regions in the Philippines by inspiring other regions to create their own arbitration centers and create linkages with these regional arbitration centers. We are hopefully Davao and Mindanao will be creating their own arbitration center, and we are highly supportive of what Mindanao is going to do if they do create their own arbitration center. Our vision is obviously dispute resolution for all. Next slide, please. So I'm the president of the Philippine Arbitration Center. Together with me are the board of trustees, namely Judge Cyril Regalado. Next slide, please. Judge Vicente Go, Attorney Dominic Paul Oso, Attorney Roy Villa, Attorney Nelly Regalado, Dean Jose Mari Tirol, Attorney Domingo Oso. You will note there are two judges in our board. It shows that because we started our awareness lecture in ADR with the judges of Iloilo. So we are really proud that insofar as ADR and arbitration is concerned, our judges in Iloilo are very, very aware, are very, very familiar of what to do with arbitration disputes that goes to court. Because of that awareness and obviously the support of these judges who are part of our board. So we are proud to say on September 24, 2021, that's why we are the last to do this presentation. Next slide, please. September 24, 2021, the Office for Alternative Dispute Resolution duly accredited the PACV and our first batch of accredited OADR arbitrators who will concentrate arbitration and ADR practice here in, especially in Region 6, are Attorney Dominic Paul Oso, Attorney Roy Villa, Attorney Nelly Regalado, Dean Jose Mari Tirol, Attorney Roan Hipunia, Attorney Patricia Go, and Attorney Marical Villanueva Hibales. So the PACV, next slide, in partnership with the University of San Agustin College of Law, conducts seminars and workshop, including mock arbitration as a way of promoting and encouraging the use of ADR, particularly arbitration for the settlement of disputes and international commercial disputes. The organization collaborates with the different partner organizations engaged in ADR. That's why most of the heads of other ADR organization institutions and the PI are partners, so we know each other, and we are actually appreciative of what our older institution and ADR communities have done for PACV. To the conduct of seminars and workshops to expose the law students to different arbitration setting. So next slide, please. So this is how our simple arbitration process works. Next slide. In line with the intent of the PACB to be in the forefront of advancing dispute resolution procedures and advocating the use of technology and ADR, here in the Philippines, the Board of Trustees of PACB approved in 2020 the holding of all PACB arbitration hearings virtually. So we're testing right now how to if we could do all our arbitration hearings virtually, unless parties will consent to a face-to-face hearing, subject to Philippine government guidelines on the matter. So on 2022, our plan is the PACB will be offering virtual face-to-face or face-to-face mediation services and shall be processing our accreditation as a mediation institution. So that's the PACB for all of you.
Thank you, Attorney Jonar. As mentioned by Attorney Jonar, well, one, they are the first to be accredited in the Visayas region, and then they've only recently been accredited and certified by the OADR. Another accredited and certified organization or firm by OADR is the Kalau Prasad and Hofilenya Law Firm. So it's the first ever law firm that we've accredited and certified. Unfortunately, they cannot be with us today. So can we bring back all our representatives from our private ADR provider organizations? I just have like two questions to you so that we can encourage those who are with us today in YouTube and Facebook to be more active or to actually join any of the organizations with us. So maybe my first question to you is that what are the benefits of being accredited by the OADR? Right now, maybe we can first call on Attorney Don Mark.
Thank you, Attorney Ali. I think the being an APO provides a lot of benefits to an ADR organization like the Philippine Institute of Arbitrators. But I guess I can highlight four of those benefits. I think one is credibility. As I said, in other countries, arbitration is an ADR is really very popular as a mode of dispute resolution mechanism, and I think it's mainly because of the support from the government and the fact that an ADR organization in the Philippines is accredited by the OADR. I believe provides that organization credibility. Second, and I've seen this over the last several months, standard. Because I think being accredited by the OADR raises the standard of an accredited organization. It's a bit more difficult for the organizations in the sense that we need to comply with the requirements, but I think ultimately that benefits the organization because it raises the bar for being an ADR organization in the Philippines. Third would be integrity. I think the fact that an organization is being, I guess, encouraged, supervised, or pushed by a government agency, of course, also encourages that organization to have integrity as an institution. And then finally, and I guess for me most important, would be involvement. To be involved in looking at initiatives in respect of ADR in the country is really one important aspect that being an accredited organization by the OADR is. And we're happy that the OADR has reached out to the Philippine Institute of Arbitrators over the last year or so to ask us about our inputs on certain points. And we really appreciate that opportunity. Thank you, Attorney Ali.
Thank you, Attorney Don. May I call on Attorney Jock or Attorney Jack?
Thank you, Ali. No, I'd like to echo what Attorney Don Mark said. For us at PICCR, we're a young arbitral institution. So being accredited really gives us that stamp of credibility, which we really appreciate. But for me personally, I think the primary benefit that we have is, having access to your team. No, the OADR's energetic and efficient team led by Executive Director Alogo. The regular coordination meetings that we have provide us a clear insight into the directions and policies of the OADR. We really truly appreciate the lively exchange of ideas between our teams, and that makes us affirm that we are on the right track with our mission and vision. I think I might be the only participant to say this, but I think one other benefit is having the policy compliance and monetary service of the OADR. As I said earlier, the PICCR is a non-stock, non-profit arbitral institution, and it's run completely by volunteers. No, so the diligence of the compliance and monitoring division in nudging us along, giving us reminders on matters like our website content. That's something that we truly appreciate.
Thank you, Attorney Jock. May I call on Attorney Arleo?
Yes, hi. Thank you. Of course, all those things that Attorney Don Mark, Attorney Jock has mentioned is we echo that and we share that sentiment. No, but aside from that, being partnered or accredited with the OADR, it serves like as a badge of competence of the APO and the neutral. No, So once you have that, you can the public can be assured of the quality of the ADR service being offered by the institution or the neutral concern. No? So again, just to reiterate what Attorney Donmark and Attorney Jock said, the credibility, the integrity, the expertise, involvement, all of that. Once you are, because you have to be accredited and go through an application process which is vetted by the OADR before you become included in that roster. No, so again, it gives the public that assurance that these are trustworthy and credible ADR experts and practitioners.
Thank you, Attorney Arleo. May I call on ED Mia, Executive Director Mia.
Thanks, Attorney Ali. I think a lot of a lot of our friends here mentioned already, the benefit of being accredited, no. But then I just wanted to add, we've been partners with the OADR for many years already, even from the very beginning. Even when we were still just drafting the law, the RA 9285 with the DOJ team, no, and then through all of these years, we've seen how dedicated the people behind ADR is in the field, and knowing that you have people institutions that support your advocacy, that's a huge thing for an NGO, a small NGO like us, no. So we really appreciate all of the support, and you've been doing a lot of online webinar series, and I've seen that you've reached like thousands and thousands of people. That also is a huge benefit for a small NGO like us, no, to allow us, invite us to talk about our service to the public. So it really, like what was mentioned by our friends, no, it really adds to the legitimacy of our organization, and of course the practice. And then it really, OADR has pushed us to do more for the Filipino people, and we look forward to the partnership, and doing more webinars like this.
Thank you, Mia. As mentioned by Mia, for 2021, the OADR has partnered in most of our webinar series, webinar episodes with our partner organization. So we've conducted episodes on mediation together with the core and with the NCM and with MedNet. So may I call on now NTM, Geraldine? May we have your thoughts? Thank you.
Yeah, thank you, Attorney. So I guess together with MedNet, kasi sa NCM we are non-lawyers, and being an APO kind of gives us that legitimacy as well. And Miss Mia knows the aches and pains of us trying to get accredited. So finally it's done. Thank you for all the support and for this alignment. I think what it can do for us as ADR practitioners is really to promote the awareness and traction. Despite the fact that ADR law has been around for some time, it's still not a byword, not so much a byword. Siguro dapat yung mga teleserye next time, imbes na sabihin, dadalhin kita sa korte, dapat sabihin, dadalhin kita sa mediation, tapos nakangiti pa. But kidding aside, I'm just so optimistic about the future of ADR in the country. Thank you so much.
Thank you, Geraldine. And as you mentioned, MedNet, may we call on Kiefer? Or Kiefer, are you with us? I think he's
Hi.
having
Yes.
problems.
Hello.
Oh, there. Hi, Kiefer.
Yeah, we feel very much the same way. We were accredited with OADR before, but it took a while to get reaccredited. We reaccredited this year, and the benefits really is, as the others have already mentioned, recognition as a mediation institution. It's really huge, the legitimacy that that our neutrals are able to get when they're able to say, "Oh, hi, when they can introduce themselves as an OADR accredited mediator, and also other things like networking with other ADR practitioners and resource exchange with OADR and other ADR practitioners. So yeah, ever since we got reaccredited, we've been getting a lot of help from OADR. It's really been massive, the amount of traction that we get as a small NGO in promoting our activities and our events. Yeah.
Thank you, Kiefer. And last but not the least, our one of our newest accredited and certified organization, Attorney Jonar.
Well, obviously, I agree with all the speakers, and most of them are my friends also. Especially Don Mark, who we would PACB would like to acknowledge because he always great help in helping PACB when we were starting. You have to understand that again. The perception of people in the region, no, iba talaga, magaling yung Manila, no. So if it's not a Manila base, most likely you're questionable. So for the fact that the PACV, who is based in the province, in the region, is certified, no, it creates a massive credibility for us to push uh, for our programs and disseminate more. And hopefully, since other regions nakita na nila yung that there's a regional arbitration center, why not build their own? And we want to be that model that inspires them to do so, because again, our belief is the more we show to everybody the beauty of ADR, the more we make them aware, it's going to be that will be the starting point that ADR will be a common thing, like ito telenovela, as Gina said a while ago, no? So this it's really is something very very important for us. And again, no, as I've listened, no, everybody has been chiming about how hard it is to be accredited, how demanding it is, the OADR is when it comes to accreditation. That's the same thing with us. And but at the end of the day, it's worth it because again, that also means that the standard of the OADR is very very high.
Thank you, Attorney Jonar. Yes, as mentioned by our guests this morning, the accreditation and certification process of the OADR is quite rigorous because we really wanted to assure the quality that is being provided to the government or to the public. So rest assured that the faces that you are seeing in your screens right now are the representatives of organizations that really provide quality service in terms of alternative dispute resolution. So again, thank you. For those who are asking how can we be accredited and certified, maybe as a closing, I'll ask you, each one of you, what is your notable experience as an APO, and maybe you can provide the details as to how our participants in YouTube and in Facebook can get in touch with your organization or how they can acquire your services. So maybe I can start off with in my screen, Kiefer.
You can reach us through our Facebook page. Can I send it in the comments or?
Yeah, please do. So, if for everyone who wants to connect with MedNet, Kiefer, you can send it to our chat, and then our secretariat will be posting it in our Facebook comments and in our YouTube comments. Any last words or maybe some encouragement as to how why people should join MedNet?
Just contact us through our Facebook page. Sorry.
Yeah, so thank you, Kiefer. For those who are interested in the works of MedNet, you can there. It's in the comment section. It's facebook.com/MedNetPH. Yeah. If you want to acquire their services as a mediation organization, or if you want to join them or be one of their roster of mediators, just a quick note, those who are accredited and certified by OADR, they are regularly posted in our Facebook page and in the website of DOJ. So for those, I believe most of our audience right now are from government agencies or government entities. You can look
into our posts, and you can see those organizations and our accredited and certified ADR neutrals. May I call on Attorney Arleo for your last words?
Yes, hi. For those who would want to get in touch with the PDRCI, you could visit our website, www.pdrci.org. We also have social media accounts, so Facebook, LinkedIn, Twitter, and Instagram. In fact, Attorney Pueblo is the chairman emeritus of our social media committee. So to be an accredited arbitrator or mediator with PDRCI, you can attend one of our trainings. This year, we've actually had 7 trainings. We've had our first regional commercial arbitration training. We've had the first sports mediation training, and that is first tribunal secretary training, file counsel training. Then we also have our twice a year commercial arbitration training webinars. So you can inquire with the secretariat about those training schedules, and then you can join us and know more about arbitration, mediation, or other forms of ADR. Please don't forget, you don't have to be lawyers to be in ADR. Okay, so this is open to even to non-lawyers. Thank you.
Yes, thank you, Attorney Arleo, and thank you for noting that. This is one unique, I think, characteristic of alternative dispute resolution. It is open to all. You do not need a legal background. All you need to do is to be knowledgeable and be passionate about alternative dispute resolution, as what others in the screen right now. So, may I call on Geraldine?
Yes, ma'am. Our website is ncmmediators.org, and we have a LinkedIn page. And I guess, borrowing your words, we are passionate about helping, especially the MSME. So please contact us.
Oh, so for small, medium enterprise organizations, we have the NCM. May I call on Attorney Don?
Thank you, Attorney Ali. Why should you join PIRB or PIRB? As I said, we're not an arbitral institution, so we don't administer arbitrations. We are more of a training institution, and we try to promote arbitration and ADR as much as we can. So if you are passionate, as mentioned by Geraldine, if you are passionate about ADR and are willing to work hard on a voluntary basis, do join us. But that's not all. A lot of our members, and we've been around for quite some time, a lot of our members, I mean, although we are not an arbitral institution, a lot of our members have really grown in their arbitration practice. For example, RJ, Attorney Arleo, we were PIRB members in the past, and now he's Executive Director of PDRC. Attorney Jonar is also a PIRB member, and now he set up PACB. And Attorney Jock is also PIRB, and she's an officer of PIRB, and now she's an officer of PICCR as well. So, I mean, if you want to grow your network in the arbitration community, join us. PIRB.org. You'll find all the information you need there. Thank you, Attorney
Yes.
Ali.
Thank you, Attorney Don. So we can see ADR community is a small community, and almost everybody knows belongs to almost similar organizations. And I remember I attended some of their activities, and it's really not just about doing trainings and holding proceedings, but also building networks with your peers and colleagues. So may I call on Mia for the core group?
Hi, thanks. What do I share? Okay. No, really mediation really brings out the best in everybody, because you were asking about, our experiences as an APO, no? And that's one of the things really that is very clear, when we do our service out there. So it brings out the humanity, it brings out the best in everybody. And when you start the dispute resolution process, people are angry, they're stressed, they look their worst, but then they come out of the other end with really smiles and bright eyes and hope, no. And that's really great. It's giving people hope, for a better solution, no, to what they are actually going through. So yeah, if you'd like to know more about the Conflict Resolution Group Foundation, our website is thecoregroup.org.ph. We are on Facebook, the Core Group Foundation. That's our Facebook account. And you can follow us on Facebook because we have regular webinars, free webinars for the public. And it's not just limited to ADR. Like I said, we do a lot of, science related, physiology and psychology. So if you'd like to, get into wellness, like mindfulness, we use mindfulness in mediation. We do use coaching in mediation. So if you'd like to know more about these practices, very short webinars that we have on a monthly basis. So just log on to our website. Thank you.
Thank you, Mia. And now, Attorney Jock.
Thanks again, Ali. So for everyone who wants to avail of PICCR services, please check out our very comprehensive website, www.piccr.com.ph. So everything that you need to know is there. Our very reasonable fee structure, our model clause, our arbitration rules. We have a flowchart there of our process, all the forms and the pertinent guidelines. So please do check that out.
Okay, so the website, I think, is flashed in your screens. And for those who want to check it out again, you can browse through again the comments. Our secretariat placed the different websites of the organizations in the comment section. And maybe last but not the least, may we call on Attorney Jonar?
So aside from thanking the PIARB and Donmark, I would like to take also this opportunity to thank the PDRC. Again, the PDRC helped jumpstart PACV because it was PDRC that helped us with our lectures with the judges here in Region 6. The fact that I'm thanking these people also shows that we as institutions and as ADR groups are actually more of we're not competing actually, we're synergies. We help each other, and the main goal of that is to enhance the information of ADR to everybody. And we really thank what the OADR is doing, especially with regards to providing awareness to government instrumentalities, to government officials and employees of the use of ADR. Could you imagine if all of these local government units, all of these government entities will be more appreciative of ADR in all its facets. So it's really an amazing future for ADR because also of what OADR is doing. So if you may contact the PACB at philarbcent in the Visayas at gmail.com and our Facebook page.
Okay, thank you, Attorney Jonar. So that wraps up our session for our ADR private provider organizations. Again, thank you to the representatives of our partner APOs. You've been a great help to the OADR, not just in this particular convention, but in our activities when we all came in OADR. So again, thank you very much, and we look forward to future collaborations and cooperations with you. So again, PIARB, the Core Group, PICCR, MedNet, PDRCI, NCM, PACV, and the KPH Law. Thank you very much for all your help and support to the Office for Alternative Dispute Resolution. So at this juncture, let me take the stage, and as we are near to the closing of our convention, let me just take this opportunity to thank everyone for staying with us
in the past 3 days. This convention has been a long process in the making, and I would like to thank the people behind, those who are behind our cameras and laptops in front of me. I would like to thank you for really exhausting all you can and putting so many efforts in pulling this convention. So thank you to the people from the Office for Alternative Dispute Resolution, specifically the Public Information and Promotion Division, who headed and spearheaded this particular convention. It is the first time for OADR to invite international guests and to have this international event. So as we transition to the conclusion of our event, may I introduce to you our Executive Director, who will be providing or giving us her closing remarks. Attorney Irene De Torres Alogoc is the inaugural Executive Director 5 of the Office for Alternative Dispute Resolution, or OADR, an attached agency of the Department of Justice. She is a professor at the New Era University College of Law and Tarlac State University School of Law. She formerly served as Secretary and member of the Board of Directors of the Association of Government Internal Auditors, Incorporated. She delivers lectures in mandatory continuing legal education covering topics on alternative dispute resolution. Attorney Irene is a trained government manager and a career executive service eligible. She has over 10 years of extensive law practice and has held key positions in all 3 branches of the government. Her passion for public service and desire to innovate is evident in her dynamic government service record, which includes her appointment as Acting Director 4 of the Internal Audit Service of the Department of Agriculture, her designation as a Court Attorney 5 at the Judicial and Bar Council, and as Director 2 at the House of Representatives Electoral Tribunal prior to her appointment to her present position. She had her training on strategic conflict management for professionals at the Singapore Mediation Center and on comprehensive course on international arbitration under the Chartered Institute of Arbitrators New York branch and the Columbia Law School. She is also a trained arbitrator of the Philippine Dispute Resolution Center, Incorporated. Attorney Irene represents the Philippines as one of the delegates to the United Nations Commission on International Trade Law, or UNCITRAL, Arbitration and Conciliation Dispute Settlement Working Group 2, and Investor State Dispute Settlement Reform Working Group 3. Attorney Irene obtained her law degree from the Arellano University School of Law and Bachelor of Arts degree in Legal Management from the University of Santo Tomas. She is also a TESDA certified bread and pastry chef. Attorney Irene is the author of the book titled Philippine Alternative Dispute Resolution, which highlights the different ADR mechanisms and practices in the country like arbitration, mediation, ADR in the judiciary, ADR under the Katarungang Pambarangay system, ADR practice of indigenous peoples, and other ADR forms. Her book, which features simplified illustrations of pertinent legal provisions, updated rules and procedure, relevant jurisprudence, and DOJ opinions, sample pleadings, and legal forms, aims to keep readers abreast with the latest developments in ADR. Again, let us all welcome our Executive Director, Attorney Irene De Torres Alogoc.
Institutional partners, resource speakers, and esteemed guests, our treasured participants, ladies and gentlemen, good afternoon. You have probably heard the aphorism that a rising tide lifts all boats. This adage is most commonly associated with economic conditions, but I have always interpreted it to mean that a good thing benefits everyone. In similar fashion, I am of the opinion that information technology is a metaphorical tide that raises all symbolic ships, including alternative dispute resolution. Since the advent of the internet, and the derivative technologies that emerged from it. The digital revolution has revolutionized and continues to transform the world around us. And over the last 2 days, you have heard from our learned experts how technology has converged with alternative dispute resolution to create a new system that is more efficient, cost-effective, and flexible than traditional approaches to dispute settlement. A system that combines the proficiency of ADR with the power of technology. A system that is known as the Online Dispute Resolution, or ODR. While Alternative Dispute Resolution Act of 2004 was passed nearly 2 decades ago, ODR is still relatively new in the Philippines. Admittedly, and with pride, ADR has already achieved significant progress in the country. In response to the rising costs and delays associated with litigation, an increasing number of people have embraced the much-needed reprieve provided by ADR. Since its inception, the Office for Alternative Dispute Resolution, Department of Justice, has persistently emphasized the benefits of ADR to complement the ever-increasing demand for fast, reliable, and affordable dispute resolution options as an alternative to litigation. As you have observed in the OADR's report, we have maintained and improved on the agency's gains year after year. And as we anticipate that the growth trend will continue, we will work even harder to outperform our past accomplishments. We are convinced that ODR provides a wellspring of opportunities for us to achieve our objectives. With over 7,000 islands, the Philippine archipelago is an ideal landscape for ODR rollout. The global pandemic has compelled us to delve deeper into ODR. And we have discovered that not only does ODR fulfill the needs of our stakeholders, its framework can also be easily crafted to accommodate all forms of ADR mechanisms. We have observed that every modality of conventional ADR, including arbitration, mediation, and conciliation, can be migrated to ODR. It is for this reason that this year's National ADR Convention has been rigorously organized to include ODR-related themes and speakers. The OADR will use all of the information gathered at this event to help build consensus among its stakeholders, particularly in setting standards of practice. It will also continue to monitor international ODR benchmarks and implement those that are relevant and useful to our circumstances. The OADR is aware of the constraints of a 3-day event in terms of the degree of coverage of highly technical topics such as ODR. For this reason, it is with great pleasure that I announce that we will be conducting a range of training and information dissemination initiatives next year. Our team has already scheduled a planning session this month to fine-tune our working drafts. As we conclude this event, you can be certain of 2 things to look forward to in January 2022. The first is the release of our training calendar, which will include all our scheduled full course training activities for the entire year. The second is the release of a provisional calendar of OADR public information and promotion initiatives, including the 3rd season of the renowned OADR webinar series. From the bottom of my heart, allow me to express my sincerest gratitude to all of you for joining the National ADR Convention. May the tide of ADR lift us all as we embark on the new year ahead. I wish everyone good health and good fortune. Thank you.
Thank you very much, OADR Executive Director, Attorney Irene D.T. Alogo. Ladies and gentlemen, This has been the second National Alternative Dispute Resolution Convention, or the NADRC 2021, with the theme Justice in the Digital Era, Synergy of Traditional ADR and Technology. Again, we express our utmost gratitude to all our distinguished speakers, development partners, international partners, government agencies, government-owned or controlled agencies, and our dear participants for joining us in the three-day event. For post-event survey, you may scan the QR code on your screens. And for other updates and information about ADR, please visit and follow our official Facebook page, Office for Alternative Dispute Resolution, or OADR. See you in our upcoming activities, events, and initiatives. Good day and stay safe.